proceeding. We have communicated, my lord, day after tomorrow again, my lord, prior to day, my lord, they again served the notice for demolition. We have challenged the same, and it is item number 425, and they have indicated that on 29th November 2023 it will be demolished. During pendency of the appeal.
Have you put the other side on notice?
Yes, my lord, I have served. My lord, yes, day before yesterday, my lord, I have filed. My lord, I have served. Not only that, my lord, I have annexed the notice. My lord, I am grateful.
May I have your lordship's leave? Madam, may I have your lordship's leave? May I have your lordship's leave to want motion, my lord, which is moved with the.
Have you served the other side with regard to the extension of interim order? Please put the other side on notice.
This matter was moved with the action which my lord did not see any urgency. I am for the perfect respondents. Matter was directed to be listed with the regular bench, my lord. But my landed friend is not coming to the court, avoiding service. But I sought to serve him upon notice of 20th November. I have been granted permanent permit. Timetable was granted granted for limited period. Because of the pendency of the matter, my lord, timetable has not been renewed, and my client's vehicle has been.
Who is appearing for the?
With Alain Felix, my lord. But he is not coming to the court. But I have annexed the notice also, my lord. My client has been searching, telephoning, 9 telephone yesterday, times. He telephoned, my lord. Still then he is not appearing. And on the other JPU yesterday, your lordship was pleased to dismiss 3 or 4 matters. He is not appearing. What is your lordship?
Yeah.
May it appear, my lord.
Your lordship's kind indulgence to mention one matter, my lord.
May I have
Your lordship kind indulgence to mention one matter, my lord. This matter was heard lastly on 6th of October 2000. This matter was heard, my lord, on 6th of October 2023, my lord. Lordship has fixed this matter today. Lordship, the interim order was extended till 30th of November, my lord. But the matter is not listed, my lord. This is the only reason. I have annexed the server copy, my lord. The Group 7 hearing.
May I have a lordship kindly leave to mention one matter upon
Tuesday, my lord. Usually, lordship takes.
Today, group 7 matters will not be taken up. That's why it's not listed. It will appear automatically.
Tuesday, my lord, let it take.
But action bench at 2 p.m. So group 7 matters were not listed. It will appear on Tuesday.
Oh, my lord, upon notice I am mentioning before your lordship, this matter relates to the unauthorized occupancy of government land. My lord, matter appearing. My lord, I have given.
Sir?
Yes. Madam, may I be permitted to mention when I am authorized lessee of mining on 7th of March.
Are you mentioning upon notice?
Yes. On 7th of March 2020, my lord ordered a proposed which on suspension order of mining activities. My lord, this court already directed to decide the show cause. I have replied. Till that it has not been disposed of.
My lord, I'm mentioning on notice. One, my lord, extension of this matter was fixed for hearing on 9th of October. Your lordship couldn't take it up at that time. My lord, this is the matter where allotment of land was cancelled. My lord, Mr. Kishore Datta was on the other side. He had completed his arguments. We only had to give our reply, my lord. If any day can be fixed, my lord. And well, yes, my lord, it's a red, my lord. And my lord, the interim order is till 30th of November. Well, any day, my lord, your lordship will fix. We will take 15 minutes to finish our arguments. My lord, this was allotment of land. My senior Mr. Mitra had submitted. After that, my lord, Mr. Kishore Datta, he had completed his arguments. We were only to reply. My lord, this is I've annexed a copy of the last order also. Yes, my lord. Yes, my lord. Yes, my lord.
Yes.
Oblige, my lord.
It's in the monthly list.
Monthly list. In the monthly list, one motion for
My lord, may I leave to mention this matter, 2 matters, serve the notice all sides. My lord, repeated directions, they have not filed any oppositions. They have appeared for upgradations, my lord. The grade urgency in this matter, similar point, my lord also decided, and several bench also decided this point. Will not hearing matter, upgradation, any day, my lord, we should that matter, my lord.
My lord, may I pray for one matter for upgradation, item number 202. My lord,
notice?
My lord, if my lord allows, I will immediately give notice.
Mention
Mr.
upon notice.
Priyobrata Bottomwell is
Notice, mention upon notice, okay?
My lord, may I permit to mention with notice to the other side, my lord. My lord, my vesting order already been set aside by this honorable division bench of this honorable High Court. Despite of that, my lord, without giving any, my lord, compensation, my lord, the Barauni Huldia gas, my lord, the authority, my lord, taking up my land and cut down my all the trees and
Give the
kindly, my lord, please, the
notice.
motion matter, my lord. Very urgent. Please notice to the other side.
My lord, item number 543 of monthly list of October, there is a need of extension of sand mining lease due to. Yes, my lord.
You're mentioning upon notice?
Yes, my lord.
There is the notice.
Notice also have served the notice.
Yes.
I have served the notice.
Upon notice to the other side?
Yes, my lord, I have
Please,
served.
the notice, show me. Notice, sir.
Ashok, may I have permitted to mention one matter for including the list of contempt application.
You got the fresh one, give the number.
Lordship,
May I,
Yes.
may I have your lordship's leave to mention a matter? Lordship, this order has been passed by Honorable Justice Vivek Chaudhary on 18th October 2023. My lord, I am praying for correction of this order.
How can I correct?
My lord, your lordship has have the determination onwards 2027.
How?
From 2027, Group 1 motion matter,
2017.
2017.
But such matters are designated to some other bench, please find out.
Yes, my lord, but
Correction, etc., have been assigned to some other bench.
yes, my
I
lord,
cannot correct the order of some other.
but till 2026, there was mentioned this. Till 2026,
2016, I am not dealing with 2016 matters.
this
I'm
matter
dealing
is from 2023.
It is some order which needs to be corrected. It is not my order. So there is a separate bench designated for this. Please find out.
Lordship, may I mention, I served the notice other side. Urgency is a petitioner's land to be
Yes?
petitioner's land to be used by the respondent without any authority.
You put the other side of notice?
Yes.
See, they can mention.
Your lordship, may I be Your lordship, may I be permitted? Your lordship, it is a matter of restoration application, your lordship. Earlier also I have mentioned, but the matter is not coming in the list, and I have yes, your lordship.
It's called the days. Please.
Item 1, my lord,
And for the
item
petition,
number 1, my lord, I have been instructed by the department to appear in this matter upon receiving mentioning notice from my learned friend. But my lord, as per my instruction, they do not have the copy of the application. So lord, I have requested my learned friend.
Your lordship, this is with regard to initially when I moved the matter, your lordship, for grant of interim order, your lordship directed me to deposit the entire amount that I have deposited. Subsequent,
Withdrawal of the amount.
yes, your lordship.
My lord,
Subsequently, the matter was remanded back to the industry.
Instructions for this?
yes, my lord, let a copy be served upon me. I will take instruction.
I have served long back, 31st of July, they have received your lordship.
Not today.
Yes, I have
Your lordship, can it be on Wednesday, your lordship, on Tuesday, I will be held up.
There. Affidavit of service. On prayer of the state respondents.
my lord, Provident Fund authorities. Provident Fund authorities.
Oh, you're the provident fund. On prayer of the respondents, the matter is adjourned. Paragraph, let the matter. Why provident fund in this court now? In this court?
Your lordship, the order was passed when your lordship has the determination, your lordship. Presently, as because the order, I was seeking clarification of your lordship's order. That is why I have filed before your lordship.
Okay, come back. Let the matter appear under the same heading on 29th
Obliged.
Wednesday. 29th November.
Obliged.
Item 2,
My lord, in this matter, before my learned friend starts, my lord, in this matter, Mr. Mahato is appearing for the, my lord, the state respondents. My lord, you are sure?
I mean, maybe yes.
State respondents?
No, my lord.
তাহলে তুমি আছো
My lord, if my lord recalls, review, withdrawn, again review, again withdrawn, and now.
I'm sorry, madam.
No, no.
Yes, there is a compliance.
Lord, day before yesterday only I have received, Lord. I have not talked with the department. I got. No,
Yes,
no, Lord,
yes,
kindly, no, Lord, kindly give some time. So in
You see
in the
that
next,
granted to you this case,
Lord, I have,
2017 matter.
Lord, I have, Lord, I bow down to your Lordship, but I have been engaged recently, Lord. Lord, kindly give me next week time.
That's
Lord, it must, Lord, but kindly give me next week time, up to next week.
changing counsels to save himself, not possible.
No, Lord, but next week.
Not today, rest assured that Tuesday a rule will be issued.
My Lord, yes, Lord,
If
as
there
your
is no
Lordship,
compliance.
as your Lordship.
And the petitioner says it has not been complied with as yet.
I will, my Lord.
Item 3,
Item 3, I am for the petitioner, Lordship. Affidavit service is not ready. They are received, Lordship.
Since affidavit of service is not ready, comma, let the matter stand over till 8 December.
Yes, ma'am. I can serve another notice to they are not appearing.
Sir,
Yeah.
is Mr. Devi?
Hey, I am sorry.
Sir,
I serve a notice, Lordship. 8 is the matter is.
item 4,
My lord, in this matter, my lord, I am contemner. I pray some time.
For the petitioner, my
I
lord.
pray some time as because my lord, as per my report, my lord, that is the no utilization of those land, my lord. So my lord, I ask him to come and
ask for time of the earlier date also.
yes, my lord. My lord, report has come, my lord. And in the report, my lord, if your lordship will see the report.
It is only a part compliance, my lord. They have assessed the value. But it is admittedly, my lord, from the documents that there is no fund for them to give it to me.
That is the last page. my lord.
So let him come.
My lord, at
That
the
is I want to find, my lord, affidavit. That
On prayer of the alleged contemner, the matter
Thank
is
you,
allowed.
Thank you. Thank you.
Matter is allowed. The matter is adjourned. And let the matter appear under the same heading on 7 December.
77.
much obliged, my lord.
item 5,
I am for the petitioner, my lord. Kindly see the last order, my lord. No, my lord, no.
compliance.
Not part,
I'm being-
nothing, my lord. No intimation, my lord, till date, my lord. Kindly see the last order, my lord. Kindly see the last order, my lord.
বলে দিই এটা just
আমাকে একটু copy দিন।
my lord, a decision has been taken in the meeting of the district land purchase committee to purchase the land, my lord. It has happened on 10th of October 2023, and the resolution has been taken, my lord. The next page is the resolution. The proposal is being sent to the irrigation waterways department. So they have initiated that, my lord, there are two parts of your lordship's order. My lord, in your lordship's solemn direction was to initiate a proposal for direct purchase of the plot in question. So they have initiated from the petitioners and complete the entire process exercise within 3 months from the matter. That has not been completed. I'm being very candid to your lordship, my lord. They have initiated, just they have initiated. On 10th of October, they have taken that steps.
So I'll give you a month's time.
My lord,
Order was
your lordship,
passed
your
on 6th
lordship
April, my
may
lord.
pass any orders, your lordship.
Order was passed in
yes.
6th April
Well, thereafter they
2022.
preferred an appeal.
Paper appeal.
Their appeal was dismissed with a cost of rupees 1 lakh, my lord. Those are there. I am a new entrant in this matter, my lord, but your lordship may pass any order because your lordship's order is there. The direction has to be carried. Direction has to be carried. They have to complete the process, and it's a order of 6th of April 2022.
When was this decision taken?
Well, on 10th of October, if your lordship kindly sees 2020.
They will come back on 4th January.
My lord.
And I expect entire compliance, total compliance.
Lordship may kindly record, my lord. My lord. They have to. Lordship may kindly.
Learned counsel for the alleged contemner submits, comma, on instructions, comma, that
আমাদেরটা নয় এটা
the district magistrate
Yeah.
Jharkhand
কোনটা
পুরোটা
has
পড়াশোনা শেষ হয়ে গেছে নাকি?
আচ্ছা বাবা,
that in a resolution
কি বলছিল ওরা তো যাচ্ছি।
taken by the district land purchase committee on 10th October 2023, it has been decided that the plot in question shall be purchased directly from the
It is scheme number 2.
and proposal and such proposal shall be sent to the Irrigation and Water Works Department. The council seeks accommodation to comply with the order under contempt in its entirety. Paragraph, let the matter appear under the same heading on 4th January. 4th January. 4th January 2024. Paragraph applicable compliance be submitted on the agenda date positively.
Grateful.
Next,
Item 6.
Item 6, my lord, I'm praying for not today only.
I for the respondent, this is the third time they are seeking the.
Hey, Lordship, yesterday, Mr. Dijodas Chakravarti is on behalf of the petitioner. Yesterday, at the time of your Lordship, he mentioned your Lordship asked him to come today and that will be considered for, only for the DMI.
Lordship, this is the dilatory tactics. Already dilatory tactics, they are dilatory tactics.
what is your?
Yes, I am the respondent. Already demolition order has been passed and estimated takes the appropriate steps for demo. Yeah, yes.
No wonder the petition is not there. Not today. Very well. Come back
Grateful.
next day. Necessary order will be passed.
This is the third time, fourth time.
Please remind me on Tuesday. No adjournment on Tuesday under any circumstance.
Lordship.
After vacation, fourth time they are taking adjournment.
Not today.
আবার টাইম নাকি? আশ্চর্য কাণ্ড, আমার লোকগুলো না খেতে পেয়ে মরে যাচ্ছে।
Tuesday for definitely.
1.33 শতকের জন্য না খেতে মরে যাচ্ছে।
হ্যাঁ,
1.55 শতক।
Item 7.
I beg to appear for the.
My lord, I am for the petitioner.
My lord, I am praying for not today on this matter. I am appearing on behalf of the Union of India. Actually, Mr. Dayasankar, Mr. appointed in this matter, is engaged on another court on any urgent, on one urgent, very urgent matter, Lordship. Kindly.
This matter is not so urgent. That is your.
No, Lordship. I am not.
My lord, this matter, my lord,
Lordship,
the
keep this
BSF
matter for
authorities-
Tuesday. Definitely Tuesday we will do, definitely. Yes.
my lord, the BSF authorities has taken.
On the earlier petition also you took that.
Lordship, actually senior counsel appearing in this matter. I only instructed to do the.
Responsibility. Do not. Holders of the. Come back.
On Tuesday, Lordship, definitely we are doing. Definitely we will do.
Then, my lord, kindly.
12 December.
My lord, can it be taken up on Tuesday, my lord? Because they are suffering, my lord, 22 matter, my lord. From 22, my lord, this matter is pending. 3 times, my lord, I have to serve them for
Also,
coming.
2 matters are also pending, sir.
My lord, this is motion stage, my lord. They are.
On prayer of the 8th respondent, the matter is allowed, the matter is adjourned. Let the matter appear under the same heading on 12th December. No adjournment on the next.
No. I'm grateful, Lordship.
বলছে তা।
Item 8.
My lord, I am for the petitioner. Last occasion, the adjournment has been prayed by the state.
This matter perhaps was disposed by your lordship, my lord, on 14th of 11/2022, my lord.
He does not know that appeal was filed and after remand, after mentioning that matter has been listed.
Where is the order of appeal?
My lord, appeal court order, my lord. I have submitted earlier. But I am another order. Hey, kindly, it's for. আমি দিয়েছিলাম আগে। তোমাদের কি করে তোমরা সৌমিত্রদা ছিল, সৌমিত্রদা আগের দিন সময় নিয়েছে, এসব কথা বলেনি। সৌমিত্র কি কমপ্লিট করবো? মেনশনিং করতে গেছি, নেয়নি, কি কমপ্লিট করবো? কমিউনিকেট হয়েছে, ছিল তো, জানে তো। কনটেস্টেড অর্ডার on merit, the matter will be disposed of on merit.
কিছু দেওয়া হয়নি।
মেনশনের সঙ্গে আমি দিয়েছিলাম।
মেনশনিং স্লিপে?
হ্যাঁ, মেনশনিং এর সঙ্গে একটা অর্ডারের কপি দিয়েছিলাম। শান্তনুদা জানে, ওটা ইনফরমেশন এসেছিল আগে ওই অ্যাপিল থেকে, অ্যাপিল কোর্ট থেকে।
স্লিপের মধ্যে কপি দেবেন না অর্ডারে? হ্যাঁ, ওইভাবে দেবেন না, ফাইলে জজকে দিচ্ছে না।
মিসপ্লেস হয়ে যায় তো।
না না, ওইভাবে দেবেন না, মেনশনিং স্লিপের সঙ্গে অর্ডার।
ঠিক আছে, দিয়ে দেবো আবার কপি, অসুবিধা নেই, একটা দিয়ে দেবো কপি।
দেবেন কি বলুন?
They have not communicated any order to us. They have communicated the order of the, they have not.
Contested. Contested.
When the matter was disposed of, Mr. Bondavar appeared. Thereafter, they have moved before the division bench, but no order has been communicated. Whatever had been passed by the division bench. Then we are.
In the last occasion, when I mentioned the matter, he has refused to take the notice. Even, among verbally I have said. And last occasion, in the last occasion, kindly see, my lord.
Since the matter has been
In the
disposed
last
of, we have, my lord, raised the brief, my lord, let them serve a copy of the matter.
Copies, evidence of service is there, my lord. This lordship's order. After demand not, but earlier copy has been served.
Matter is disposed of.
Yes, my lord. Thereafter another copy was.
I would like to say something.
My lord, thereafter, when the appeal has been filed, the writ petition was corporated, whole petition, and the paperwork has been supplied. So 2 times I have served. How many times I can?
The papers are checked.
Signed off, because Mr. Bandapadhyay was there.
It's
And
checked.
we'll be ready on the next occasion. No further adjournment.
Yes.
On
My lord.
behalf of the state respondents, the matter is adjourned.
Yes, my lord.
Let the matter appear under the same heading on 18th September.
My lord, I am praying only a short order that will not be prejudiced. That is state respondent, that respondent number 2 will file a report in the form of affidavit. Nothing but, I am nothing.
Not necessary.
Ye-
Do you want to come back with the report?
I do not know what is.
The state has to decide whether they want to file a report.
Yes,
I
my
have
lord.
not taken up the matter at all.
No,
Let
I,
it be heard. Please come back on 18th.
yes, my lord, only report they will file, my lord.
Same heading on 18th December.
My lord, only the report will file in the form of it.
Without hearing the matter. It has
I
to
am
be heard.
ready. I am ready. I am ready. I am ready.
For an adjournment, come back on the adjourned date.
In the last date, also prayed for adjournment.
Yes, I've seen that it is recorded. Next matter.
Item 9.
Item 9, I appear on.
কত তারিখে হয়েছে?
I am for the respondent, private respondent.
I appear on behalf of the state.
Petitioner,
This
for the petitioner.
I'm praying for a short passover, my lord. My brief is on the ballot.
this is a very short matter, my lord. May I?
My lord, my consideration was, my lord, for representation of the consideration, my lord. Because, my
That
lord,
will suffice.
a illegal construction was made, my lord, by the private respondent, my lord, and that was, my lord, no action.
I am for the private respondent, my lord. Petitioner states that the private respondent obstructed his ingress and egress. My lord, I placed some photographs which shows there is enough space for ingress and egress.
Secondary.
My lord,
Construction.
no,
Egress
my
ingress
lord,
is secondary.
no, my lord, there is a,
If you have not obstructed the egress and ingress, if you have raised unauthorized
My lord.
construction, that is important.
my lord, may I submit? My lord, petitioner states that the land belongs to government.
Yes.
My lord, who determined this is the government floors or not, my lord?
The government.
There is a no inspection report. My lord, till date, I have not received any notice from government, my lord.
No, that is my sole
My
grievance.
lord, this is purely civil in nature, my lord.
That is my sole grievance, my lord.
My lord, there is grievance, my lord.
Let the executive engineer consider his
Fine.
representation. Do the needful.
Is it PW Act?
My lord, kindly.
62 Act or 64 Act? That is my question.
My lord, your determination of your lordship, my lord, Bengal Highways Act, my lord.
My lord, there is a no inspection, my lord.
64 Act, my lord.
Page 29, I think.
PWD. Annex P4.
Yes, yes. My lord. It's a big problem.
Court will not go into merits, madam. Let the representation be decided by the authority. When an officer.
My lord, my lord.
The petitioner claims to be the recorded owner of plot number 10604, comma, at present renumbered as 1556. Is Moja Hekua, HEKUA, comma, jail number 30. And complains that the private respondents have raised unlawful construction by encroaching upon PWD land adjoining his plot, comma, thereby obstructing his egress and ingress. The petitioner submitted a representation to the concerned authority in this regard on 5th September 2022, which is yet to be considered. Stop the petitioner placed for a authority to consider the representation at the earliest. Paragraph, learned counsel for the private respondents submits that the construction raised by the private respondents has not obstructed the egress and ingress of the petitioner in any manner. Stop also, comma, it is to be determined as to whether any portion of the PWD land has been encroached upon by the private respondents. Paragraph, learned counsel for the state respondents submits that it should be the assistant engineer who should deal with it. It should be 4 or 5.
4 or 5, ma'am.
Yes, who should deal with it? 4 or 5? It should be 5, I think. Highway Division, PW Roads Directorate.
Assistant engineer.
It should be 4, I
No,
think.
4, my lord. According to my instruction, 4.
Four.
Division 1.
4.
The fourth respondent be directed to consider the representation in accordance with law. Paragraph. In view of the above, comma, the representation is disposed of, directing the fourth respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents. Comma, in accordance with law. Disposed of.
Grateful. Grateful, ma'am.
Grateful.
Item 10. Your Lordship, I appear for the respondent number 6, Your Lordship. Your Lordship, before my learned senior friend starts, Your Lordship, my client is very poor, Your Lordship. This is the 12th time this matter is coming, Your Lordship. My client is not able to run the case, Your Lordship. So I'm praying that me, Your Lordship, dispose of the matter, Your Lordship, today. I will be very candid before Your Lordship. But Your Lordship, my client is not, because Your Lordship, if Your Lordship kindly sees, it is submitted by my learned friend that this is a PWD land, Your Lordship.
Let me make my submission.
Great.
Bible respondent.
Lordship.
Kindly see the order of your Lordship. 24th August 2023, Your Lordship passed an order. But I am giving a copy of the order. Oh, yes. Kindly see this order.
serve copies?
Last report.
Sir, আমাকে copy
Instruction whether the road in question is under Kharagpur subdivision.
There were three issues to be considered.
So far as the notification is concerned, we could not trace the notification. But the record shows the land is under the custody of the PWD. This PWD land.
grateful.
We have annexed the record of right. The report of my page 12.
Have you seen the report?
Just now I have got this report.
You want to go through this and come back?
I will go through the report. I have raised three questions. First question is that no gazette notification is there for the appointment of the highway authority. Now the second question, my lord, the road is under the jurisdiction of the Kharagpur subdivision, that is executive engineer Kharagpur subdivision. Now the notice was issued by the executive engineer Mindapur division, but he has got no authority at all.
Have you given an explanation to that?
Yes, my lord. That is the my report. As per notification number such and such. Last page. As per notification number such and such, my lord, the jurisdiction of Quantai Belda Road under PWD Kharagpur subdivision came under the jurisdiction of PWD Belda.
This is clarified. This is clarified.
Yes.
Page 12, I have annexed the document.
Clarified.
Gratefully, Lordship.
Page 12, my lord, I have annexed the document, the notification.
The second point has been clarified.
Yes.
So for the past point is concerned, as per the statute, the notification, gazette notification is required. Now, section 2D, kindly take the act, provisions of the act. Section 2D defines the highway authority. Section 5 says that the highway authority has to be appointed by virtue of the gazette notification. Here the notification has been, departmental notification has been issued for appointment of the highway authority. That cannot be done. That is in contravention of the statute.
Page 7 of my report.
এটা সরানো হয়নি কেন আপনি?
I am given this book, kindly see.
বইগুলো ওখানে।
Kindly see, first of all, section 2D. Highway authority means the authority appointed under section 5. Have you also got it? Number section 5.
The state government may by notification.
Yes.
It's not a
By
shall.
Therefore,
These are all very technical.
my lord,
These are all very technical. 10.3 notice has been issued. Have you applied it under 10.4?
Yes, your Lordship.
10.4.
Yes.
10.4, why should I? We have challenged this notice, section 10.1 and section 10.3. Section 10.1 and section 10.3, because we have stated that the highway authority has got the jurisdiction to issue the notice. And
Section 5 says may.
may, my lord, the intention of the legislature has to be understood in its part, because
This is all not a very technical.
no, my
Sorry.
department, only thing, departmental notification has been issued. By which power? Can you see the departmental notification? Can you see the departmental notification? What is the round of deep down? They have exercised the power as per section 5. Can you see how this power has been exercised under section 5? Department notification. Kali,
Where is the 10.3 notice?
but kindly see first of all the departmental notification. Kindly see page 10 of the report filed by SUVRA. Kindly see. At page 10, the report filed by SUVRA. Have you also got it?
No, give me a minute. Yes.
No, kindly, I am reading that. In excess of the power by section 5 of the West Bengal Highway Act 1964, the governor is pleased to hereby to appoint with immediate effect the highway authority within the meaning of the clause D of section 2 of the said act, as mentioned in column 4 of schedule
below in respect of the road and its length under the Public Works Department in Paschim Midnapur district as mentioned here. Now kindly see Kharagpur division as well as in that page. Now contact to Belda Road for locally executive engineer Kharagpur division. This is the department notification.
Report page?
Page 10. 10.
Yes.
Annexure D. Have you got it? Therefore, they have exercised this power under section 5. If you exercise the power under section 5, then we have to get the notification. You cannot, by exercising the power under section 5, you cannot issue a department notification. That is totally the derogation of the statute. If you exercise the power section 5 postulates that we have to get a notification by appointing the high authority. Therefore, you cannot use that power by issuing a department notification. That is totally in derogation of the statute. And in consonance with the section 2D.
There's a judgment of a coordinate bench of this court which says that even in without 2D, it can be.
But that is my lord, that is Jyotirmay Bhattacharya. But that is so far the section 3 is concerned. Can you see? Not this section 5. That is so far section 3 is concerned. I know this judgment.
Section 2.
Yes, section 3 is concerned. But so far section 5 is concerned, when I have got this judgment, so far the section 5 is concerned, there is no judgment to the extent. Because if you exercise the power section 5, you have to get a notification. Otherwise, you cannot do that. By issuing a departmental notification, you cannot distort the power by virtue of exercising section 5.
Do you have the gazette notification?
We have tried our level best, but we could not trace them again. This is from the record of right, it is appearing that the PWD authority is the
No
record.
dispute. No dispute.
Yes, ma'am.
That is not dispute. That is not dispute. I am not disputing that also.
He's only on authority. Of
And
the
second, my lord, second, the appointment of the executive.
You say that was a stopgap arrangement.
My lord?
You say that was a stopgap arrangement.
I kindly see the CRPC. And that's a very also important. Section 20, subsection 1 deals with the appointment of the, my lord, magistrate. Executive magistrate. Kindly see. And section 20, subsection 4 deals with the postage. But if the appointment is not being done under section 20, subsection 1, how can it be posted by virtue of exercising the power under section 20, subsection 4? I am putting question to myself. How can it be? Therefore, you have exercised the power by posting him under section 20, subsection 4. If his appointment is not being done by virtue of section 20, subsection 1, how can it be posted? And you see the section 20 of the CRPC. I am giving that. I am giving that. That's very important. What happened? Can you see section 20, subsection 1 and section 20, subsection 4? But kindly compare that. And they have the given posting by virtue of utilizing the power under section 20, subsection 4.
The notice was issued by an executive magistrate.
And kindly see page 29. Page 12, can see page 12. But kindly see page 12 of the report.
It's under section 24. He has been appointed to.
He has been appointed. He cannot give this appointment because section 20, subsection 1 deals with the appointment, and section 20, subsection 4 deals with the posting. Appointment and posting is different, totally different. If I am not being appointed, how can I post it? Therefore, this is also totally different. First of all, you have to give this appointment under section 20, subsection 1. Thereafter, for filling up the time gap arrangement.
There has been an appointment of the executive magistrate earlier. He has been subsequently posted at this place for taking
Kindly see
functions.
page 12 of the report. Kindly see page 12 of the report
He cannot
filed
be
by.
posted without an appointment. That is.
Page 12 of the report filed by Somnath Datta. Page 12 of the report filed by Somnath Datta. Have you got it?
Give me a minute. Yes.
Kindly see what he has written. In exercise of the power conferred by subsection 4 of section 20 of the Code of Criminal Procedure, the governor is pleased to appoint Dilip Mastro, who has been posted of serving officer posting as the executive magistrate in charge. Therefore, section 20 subsection can be appointment done.
He was already posted as sub-divisional officer Kharagpur.
Yes.
He has only been given this charge.
Yes.
So there is no irregularity at all.
What the contention is that?
He holds the status of an executive magistrate all throughout.
But kindly see.
An outsider has
But
not
kindly
been
see
brought-
meaning of the letter. Kindly see. But I am reading again. In exercise of the power conferred by subsection 4 of 20 of the Code of Criminal, the governor is pleased to appoint Dilip Mistro, who has been posted. Kindly see. A power of the exercise of power has been utilized by utilizing the section 20 subsection 4. Because by section 4 of 20, he has given appointment.
He has appointment is not the question, sir.
But that has been given.
Appointment has been given earlier.
No, that had been written. Kindly see that has been written. In excess of the power conferred subsection 4 of section 20, the governor is pleased to appoint.
You cannot just speak out one word.
No, I am reading full word.
Read it in its entirety.
Yes, I am reading full word. In excess of the power conferred by subsection 4 of section 20 of
He
the Code
was
of
already posted as sub-divisional
No, the
officer.
governor is pleased to appoint Dilip Mishra.
He has in charge of the Kharagpur subdivision.
Yes, who had been posted as sub-division officer Kharagpur, Paschim Midnapur as the executive magistrate in charge. Who had been posted, but the appointment had been done by section 20 subsection 4. Kindly see the meaning of the letter. Kindly see the meaning of the letter. In excess of the power conferred subsection 4 of 20 of the Code, the governor is pleased to appoint. What is the meaning that?
He's placed the executive
No, no,
magistrate.
Who had been posted as Kharagpur? Who had been posted?
He was already a sub-divisional officer Kharagpur. His appointment was already made earlier.
But that's why that has not been mentioned, because the appointment has been done by exercising the power of section 20 of section 4.
Cannot take advantage of the language. It is
Because
very
of the
clear in
contents of the letter. But
I understand your predicament. Since a 10-3 notice is all hanging on your shoulders, you are on all these issues, but these are very technical. Necessary order will be passed.
my lord, because
The points have been made by the state government.
I have the 2 points. First of all, gazette notification is marked. Otherwise,
It is a may, it is not a must.
because the power had been
Notification is there.
the power had been exercised by
And
section
the
5.
government doesn't say that they have.
I tell you, the power had been exercised by section 5. If the power had been exercised by section 5,
Dictate the order, sir.
My
I'm
lord?
sorry. Please allow me to dictate the order.
no, you also before that, I can satisfy to your lordship that section 5 has been utilized by the
Repeating the submission.
no, that's not. But if the section 5 is utilized by the government, then his notification has to be gazetted.
No, it is a may. The government may.
Yes. Yes.
And
But the power had been utilized.
There is
Kindly see, the power had been utilized. Page
yes.
10 of the report, the SUVRA. Kindly see.
Please come to section 5. Section 5 says
Yes,
may.
yes. Section 5 deals with May.
Yes.
The legislature
There is already an office notification which is on record.
office notification has been utilized by utilizing section 5.
Under section 5, yes.
Under section 5, if you utilize this power, this notification has to be gazetted. Because the power has been given to you to notify.
Government may by notification.
Yes. Yes.
Then departmental notification.
Notification.
Departmental notification can be issued by way of exercising the power section 5, whether it has been written in the act itself. The departmental notification can be issued by way of utilizing the power of section 5.
These technical grounds will not help your unauthorized.
This is not the
input of
technical
the
ground. This is the intention of the legislature. The intention of the legislature that if you exercise the power
The
section 5,
legislature is more interested in demolishing unauthorized constructions than this.
but that's not the question, my lord. But the authority has to strictly follow the statute.
Any further submission?
But these are the submission because section 5 has to be utilized and section 1 of the 20 subsection 1 has to be utilized. These are the power.
Yes, state.
And only one thing I will show to your lordship. Kindly see page 30 of the main petition. Kindly see
30 of the repetition.
main petition. I will show one example. How the appointment has been done. Kindly see, exercise of the power, subsection 1 of section 20 of the Code of Criminal Procedure. The governor is pleased to appoint Sri Sat and I have presently posted as subject officer as duty magistrate in charge. Therefore, kindly see, section 20 subsection 1 power has been utilized to appoint, not section 20 subsection 4. That's what this I am giving that reference, for example. Therefore, section 20 subsection 1 has to be utilized for giving appointment, not section 20 subsection 4. The same letter has been issued. The same letter.
Mr. Butterball, how do you explain this?
We are not saying the gazette is not there, madam.
No, not gazette notification, the third point.
Section 20 subsection 1.
Yes. Page 30 says you have appointed one of the other officers under 20 subsection 1. But in this case, it is under 20 subsection 4.
Back to the page 29, can you see, madam? Page 29.
Yes. This is also 21, 20 subsection 1.
Yes. When I have annexed the document 28, 29, 30, all are section 20 subsection 1. All are. Same later.
There should be a notification under 21, 20 subsection 1.
We have to take instruction on this point, madam.
We are taking short time on the earlier occasion, also on the same ground. Have submitted a report, but the report that doesn't cover this. Yes, that doesn't cover this, and the gazette notification under section 5 also. Section 10(3) stayed only for on this ground. When can you come back?
May deal to be said.
After vacation, madam.
No, Your Lordship, I object, Your Lordship. Your Lordship, my client is suffering, Your Lordship. In my most respectful submission, Your Lordship.
10(3) is pending, Mr. Bandapad, not after vacation. Come back. Only because of these technical grounds, 10(3) is not being executed. These are very technical grounds, but they need to be clarified. Please go through the August order of this court and point-wise please clarify. If there was an order and you have submitted a report, there was an earlier order. Report submitted on behalf of the state respondents is taken on record. It appears from the report that the issues raised by this court, issues raised by the petitioner and recorded by this court in order dated 24th August 2023 have not been answered. Paragraph, the state respondents are directed to submit a further report clarifying all the issues, clarifying/answering all the issues recorded in the said order. Paragraph, let the matter appear under the same heading on 13th December. 13th December.
13th, you want to be extended.
Paragraph, the interim order granted earlier is extended till 20th December or until further orders, whichever is over.
And the report, man, which is to be filed.
Ensure a proper report on the next one.
And only one thing, man, the report which has to be filed, let it to be served in advance. So that I can go to the report.
Grateful, Your Lordship.
আগে দিবি। না দিলে আমি করতে পারবো না। সোজা কথা।
Item 11.
Deeply obliged, Your Lordship.
Item 11.
Lord, I beg to appear on behalf of the state respondents, and I have obtained a leave from your lordship to file a supplementary report. Lord, I have served them, my lord. This is the report, my lord.
There is an application pending or extension?
Yes.
So, I have filed an application for extension of the interim.
My lord, your lordship was pleased to refuse to extend the interim order on last 3 occasions.
No.
Your
For
lordship.
application. As there was no application, your lordships granted me to file.
আমার application copy তো দেয় না না না
What is the
No.
matter about? Can we, let us see if we can hear out.
না অমর্ত্য পাল লিখে দাও।
Lordship, this matter, lordship, kindly first day of the order, your lordship granted stay. Lordship, they have filed today they have filed a supplementary report. Again, I file a supplementary.
My lord, I have not received that interim order, my lord. That this is the
Can you?
no, I have not received.
কেন?
আমাকে দেয়নি, ওকে দিয়েছিস।
স্টেটকে সার্ভিস করা আছে তো।
না রে রে। ন্যাশনাল হাইওয়ে অথরিটিকে দিয়েছিস। But anyway, my lord, your lordships.
Now, lordship, here in this report, so I have whatever I have prima facie found that in the supplementary report, lordship, I have raised objection to the one aspect that I filed an objection application that my 2 plots has been acquired. Now, 2575 and 2576. According to them, 2576 is a vested land. Now, to that extent, lordship, this supplementary affidavit has been, lordship, they affirmed. Now, they have admitted that initially this report was, when this initial notification was issued, lordship, this is the Rayati land. Lordship, kindly come to this report.
Of
Page
the
7,
national
this report today filed.
Today's report.
Yes, page 7. Prior to the period of notification of subsection 1 of section 3A, as published on 26 June 2020 in extraordinary, a report regarding the status involved in the plots as on Atho was obtained from BL and LRO Golsi 1, wherein plot number 2575 and 2576 was declared Rayat. So, lordship, initially it was Rayati land. Lordship, I am the owner of the land. I submitted application for compensation. Now my objection was considered. This disposed of. There is no indication that this plot is, petitioner is not entitled to get any compensation. There is no such, lordship, in their compliance report. Subsequently, BLRO submitted report. No, 2576 is a vested land.
Kindly read, my lord, your lordship. Next,
Let me, sir, let me. 2576 is a vested land.
Where is the vesting proceeding? The document?
Yes. Nothing, no document has been annexed. Lordship, these are the report. So, lordship, I am praying for, let there be a conclusive report annexing this vesting process. At least vesting proceeding
Where
has
is the
to be.
vesting proceeding? It has been heard for on several occasions. It should be on record now.
Nothing. This vesting proceeding, only record of right. And that record of prepared on 2021, November 2021. And lordship, another aspect is, lordship, this 2 aspects, lordship, I am praying for helping to file another report, because another point is, lordship, after the conclusion of the objection, when my objection has been considered, they under section, lordship, the 3C, they have to file a notification. Take notification that these are the land we have acquired.
Kindly takes, my lord.
That is not been annexed. Lordship, these two things, Lordship, kindly lastly, two things, let them document be produced and heard the matter final.
Lord, your lordship kindly takes page 33 of my second report.
Today's report?
Lordship, my lord.
Second,
33,
33.
Page 33. My lord, we have additional district magistrate, collect, my lord, asked from the
Yeah.
supply of vesting report, and thereafter, my lord,
Report কোথায়?
vesting report,
Proceeding টা কোথায়?
my lord, 35 pro forma report, my lord, your lordship kindly sees.
Record of right. Vesting proceeding. কোন একটা vest হলো?
This is plot information.
Lordship,
When was it vested? How was it vested? Whether it was vested at all?
lordship, my lord. My lord, I would get,
Accordance with law.
my lord, I would get back with those reports, your lordship, my lord.
Several dates have.
Vesting proceeding টা কোন
Please
একটা
come back with the
14th
report
তে
of the next
vesting
report.
করেছেন না কোন
A
একটা
report in the form of an affidavit, same
Yes.
lordship.
Several reports, but the purpose is not being served.
I understand, my lord.
Supplementary report in the form of affidavit submitted on behalf of the state respondent. Paragraph. The petitioner claims to be the recorded owner of plot number 2576, whereas it is submitted on behalf of the state respondents that the said land is vested in the state. Stop. Paragraph. Learned counsel for the state respondents seeks to use a further report in the form of affidavit annexing relevant documents pertaining to the said vesting. On the next occasion, even without a report, it will be disposed of. Several occasions have.
Lord, I would file, my lord.
It's been heard on several occasions.
Lordship,
Paragraph.
Lordship,
Let the matter appear under the say after vacation.
lordship, my lord.
Lordship, let the interim order be extended.
No, but-
I filed it.
India order that ছিল নাকি?
I'll take up the CAN application.
Yes.
There was an interim order.
Yes.
Lord, your lord, that, Lord, your interim order was there. That has been, my lord, expired.
Not extended, not
No, expired. And, my lord, your lordship on last consecutive 4 occasions refused to, my lord, revive the interim
And
order.
there was no application.
Without an application.
The application has not been served upon me.
File করেছেন।
No, the application has not been served on. My lord, let me go through the application. If necessary, my lord, my lord, will file objection to that, opposition to that.
5th January.
Lordship, my lord.
On the next day, let the matter be disposed of.
Lordship, my lord. Once for all.
Status to be maintained.
No, my lord, without any formal application, that has not been served.
Serve the application now. How can I pass an order?
So I have
The 4 consecutive occasions, your lordship refused.
the National High Authority is the National High Authority I have served.
If you are so keen on an interim order, you should have been more diligent.
Lordship, the only acquiring authority is the National High Authority. National High Authority has no objection I have served.
Whatever it is.
No, তোর ছিল বল
So I have served the copy.
ছেড়ে দাও, order আছে আর বলবে না।
Give necessary instructions to your clients not to take any coercive steps till the matter is disposed of. I'm not passing an interim order.
Lordship, my lord.
So my learned friend has no objection if the status.
How can he say that he has no objection? I have
State has nothing to
strongest
say with
objection.
Acquisition or acquiring authority.
State has to produce the relevant documents.
Yes,
Yes.
I have
but
strongest
Lordship,
objection.
But the construction is
অন্য আমি তো
has
বলে
to be
দিচ্ছি।
done in the instance of the National High Authority. He is a prescribed authority.
No, I'm বলে বলো।
And it has been expired.
Lordship, kindly Monday, Lordship, in the Tuesday, in the meantime, I am served, Lordship, for the purpose of interim order, Lordship.
No, my lord, after because he also what has fallen for your lordship?
Nothing has happened. Isn't it?
Well, your lordship is pleased to fix it on, you know,
Item 12,
5th January. Grateful.
Next.
item 12,
I appear for the petitioner, my lord. But requisition was. Ganguly's application for the state, my lord, due to his illness, he has not come. It's clarity. Not today, my lord. On the other occasion, they took time to take instruction, my lord. That
Yes.
was the last order, my lord.
He was present, he has some personal difficulty.
Due to his illness, he has
And the chair of the state, but he's not there, isn't it? So I should record, no one appears.
No, earlier occasion, I cannot say, my lord. Clerk is saying, due to illness, my lord, he has not.
I understand, but I cannot record his name.
Oh.
Can I?
All, yes, it is.
None appears for the state respondents. Paragraph, let the matter appear under the same heading on 19th December. Hope he'll be back by then.
Be right.
14. I am for the Eastern Railway Authority.
I'm for the respondent number 11. Led by Mr. Bhattacharya.
20th of September 2020.
Eastern.
Yes.
Lordship, I am submitting the report. I'm on behalf of the respondent number 11.
The dedicated freight corridor.
Yes, madam. They are the answering respondent.
They are the answering.
Have you received a copy?
But I did not receive the copy of the report. Yes, I received. I received.
I filed the report and because my lord, I am the copy of the document. The other is the legal body.
Yes, yes.
I have filed this.
I just
My
received
lord, I have
both these copies, but I may be given a time so that I can find the exception to this.
Very good. Advance copies were not served.
I'm not her junior, Lordship.
Eastern dedicated freight.
His clerk said to me to stand in this case.
Your report is also not on affidavit. Report submitted by the state respondent and report in the form of affidavit submitted respondents, state respondents. And report in the form of affidavit submitted on behalf of the 11th respondent are taken on record. Paragraph, learned counsel for the petitioner seeks to use exceptions to both the reports. Paragraph, after vacation,
I should lordship please respond. I'll be just gonna taking 2 weeks time for this.
2 weeks time. So that leads us almost to the vacation.
My lord, after vacation. And because my lord, I have filed two ABTV report, but other three report is not my lord to complete. But that is my lord.
So 10 January?
Yes, ma'am.
10
I
January.
should.
Let
But,
it appear on the
I'll be requesting my learned senior my lord for the state. In this meantime, my lord, because I just have seen that in the report, my lord, they said that there is a rule of 2012 which says that the railway, the PSUs will be responsible for giving employment and everything, and this land losers category, my lord, job can only be given by the railways, not by the PSUs. But my lord, that particular notice which my lord senior my lord has annexed, my lord, it is already my lord set aside by the honorable division bench of the Assam lordship. I'll be just requesting my lord senior my lord to go through that and submit your petition. I find that my lord in the report. This is the things. Sir, আপনার রিপোর্টটা দিয়েছেন ওটা সেটা করে দেব টেন্ডার সাহেবের ডিভিশন।
So please show the judgment on
I'll
the
do
next
that.
My lord, my submission is that we are not at
exception.
Yes.
My lord, my submission is that they have unnecessarily made Eastern Railway a party.
Let the railway.
Please remain unnecessarily till the matter is considered. Let us see the find out the necessity. Next.
14.
What is wrong with my legacy?
14.
Great.
But I am filing my report.
13 to 17 are all same.
14.
Right. 13 to 17. And the same parties, the same representations?
Same. What the state my lord, I play some time my lord to file.
Go to the state file. Are you asked for time? So let them appear on the same date.
I find the
আপনি দিদি আপনি যদি রিপোর্ট দিয়ে থাকেন আমায় কপিগুলো দিয়ে দিন।
And what about the freight corridor in this matter? You are appearing? Where is your report? Submitting it today? You are the 11th respondent here.
We have also released our payment regarding the construction already made over the property pertaining to 4 parties. And so far, last party is concerned Mr. Pakira, that is pending because that is a vacant land. So we have already made that, but since our affidavit was already made before that, so we could not annex that document with that, but leave may be granted to produce the check so that we can submit before your lordship.
So why don't you come back with a fresh affidavit without, instead of submitting it today?
My lord.
Come back on the next, I'll
My
give it
lord.
back to you.
As your lordship
You can
pleases.
annex it here itself.
But what about the previous?
Lordship.
এটা কত? এটা হচ্ছে 14 14 এটা
এটা তো সেম ছিল আমি সেম
14 মাইলট আছে
আগেটাও সেম বলছি
Yes, my lord, she does.
সেম
Previous
সিচুয়েশন
matter also.
yes madam
So will you take back your affidavit in the previous matter?
my lord I can
Let it
file
be
a
annexed in one of
supplementary
the matters. Let it be annexed in one of the matters. That
yes
suffice.
it's a one-page document my lord the check
Learned counsels for the state respondent and the 11th respondent
But
seeks
one thing,
extension of time.
exactly, but if she, my lord, hands that particular document over, then it can be, my lord, taken up, my lord, by the
It
honorable
has to be
Secretary
brought on record actually.
before the vacation itself. So in that event, I'll take the exception and lordship then but I'll be just taking this matter.
I'll serve the advance copy before we.
my
একটা কপি দিয়ে দিই উজ্জ্বল
I'm not recording any order. Please do that.
lordship
আমি তোমাকে দিয়ে দিই
Yes, sir, after
Extension of time to
Yeah.
file the affidavit, the report in the form of affidavits as sought. Paragraph, let the matter appear under the same heading on 10 January as said.
Thank you, Lord.
10 January 2020.
Great.
my lord grateful lordship
15, item 15,
মাইলট আই ফাইল দ্য
Hold on.
15টা দুটো দিলাম
Report submitted on behalf of the state.
একটা দিয়েছে
The report submitted on behalf of the state respondents is taken on record. Paragraph, learned counsel for the U.S. respondent seeks the extension of time to submit the report in the form of affidavit as sought. Paragraph, let the matter appear under the same heading on 10 January.
16,
16, I am mapping with the state matter and file my report.
Same as 15.
At a
Hold
copy.
on.
Yeah.
Next.
17,
The cause for state respondents as well as the. Time. Same. Sort form. Next.
18,
18, I am for the petitioner, my lord.
আমি কি একটা জাতি
না 18 18 also 17
18 is to Yes, have you gone through the report?
Yes, my lord, I have gone through the report. I would like to draw your lordship's attention, page 5 of the report.
Give me a minute, please. Your request for rehabilitation plot was refused.
Yes, my lord, being at that point of time, I was minor on that ground. I have challenged that notification also. They have again relied on that notification and submitted that report. They have said that a plot was allotted to my father and my plot was refused and that plot has been allotted to my elder brother. My
You
lord,
are the Holdia developer?
my lord, the plot which has been allotted to my elder brother, he has a separate plot of land, 0.2 decimal. That is 2 decimal of land. I have a separate 2 decimals of land with a structure. At that point of time, I was a minor, no doubt about it. But minor is also entitled to the rehabilitation plot because they are saying that in the notification that as a head of the family would be considered as a one and that plot would be given. Plot number 403 has been given in their own affidavit in all the documents annexed to the writ. It also shows that my father got the land as well as my elder brother got the land. I am also entitled to the land.
2 separate units.
Is there 2 separate units? They have 2 separate plots and they have got the land. And I have a separate unit, I have a structure. Now I have a family. I need that land also.
if everyone is entitled, why I would be secluded just because I was a minor? I think that is a gross violation of natural justice, means the fundamental right of a petitioner, I would say. That is where it violates the right to equality, I would say.
Yes.
Well, as per guidelines of the minor, the rehabilitation is he is not entitled.
What is the guideline? Is it said that the minor is not entitled? Where is the guideline?
Guideline is annexed with the writ petition, second last page.
Page 36.
Page 36 of the writ petition, which they are relying on. Clause 4.
Petitioner's father's land was taken by a separate LA case. Petitioner's land has been taken by a separate LA case.
But the father, no, that is not true, mother. Petitioner's father's land, mother, that is not true.
Yes, that is the case.
Plots are different, I'm saying.
The LA case is the same.
No, LA case is different.
That is what I'm saying.
Yes, LA case is different. My lord, I'm sorry to understand. My lord, from the report, it would reveal that the LA case of petitioner's father is 70, LA case number 97475.
Challenge for any notification.
And your LA case is 84 of 97.
Yes, yes.
These are two separate LA cases, Mr. Bantwati.
No, but as per the guidelines by the Roman code, an awardee identified as family should not get any land as the authorities to take care of family at the time of eviction only. Family means family consists of parents, wife, children, and unmarried couple. Therefore, once it has been allotted in favor of the petitioner, he is not entitled.
Case of a separate LA
But he has not challenged the notification.
I have challenged it.
No.
I have challenged it in the writ petition itself.
No.
Kindly see.
It is not the prayer, not in the ground.
Yes. The prayer is there.
No. I have seen.
Prayer B, my lord.
Yes, it is challenged.
Then it will be well, then there is no such ground.
Yes, there is a ground.
How it is, my lord?
Ground number 8.
Ultra virus. No grounds.
Yeah, ground number 8.
Ground number. What?
Ground number 1.
No, ground number 1.
I have taken the point.
The notification. There is the difficulties with the interpretation of the notification.
Yes.
Notification is correct, absolutely. There's nothing wrong with it. Two separate acquisition cases, two separate units.
Well, we shall file the affidavit, my lord.
I have already filed the affidavit.
The court will pass an order.
Great.
As per guidelines, my lord, he is not entitled to get any lands.
Mr. Bandapathy, you cannot just say in a sentence.
And he has not filed any exception to our report, my lord.
Is it necessary?
This is consideration of your lordships.
Exception. Even without an exception, he can make his own objections.
I cannot go beyond my notification.
His case all throughout that in terms of this notification, he is entitled. Because
But
these are
in-
two separate acquisition proceedings.
But my instruction is this, my lord. I cannot go beyond this, my lord. বললাম তো দোষটা করে বলছেন তা না সে বললাম তো
Where is the order impugned?
Order impugned is at my lord.
কত 30
34.
54 ওই একই বলো কথা বলছি এটা তো আলাদা জিও
So
এটা 20
yes, the authority you have to any submission to be made.
My lord, the development today is the direction only allotted the plot if the RS, the regulation advisory committee is advised to.
We are only for that. The
You will only allot.
only allot as per the direction of the REC. And the guideline framed by the state government and REC is the state government.
So you have nothing much.
We have nothing much.
You will only comply with the
Decision of the REC.
the writ petition will be allowed, Mr. Mandipal.
Yes, your lordship, my lord. I cannot go beyond my notification.
Allow this and the floodgate will open and thousands of minors on that ground. Many.
How can you reject a minor's application for rehabilitation? Is there any notification to that effect? That if the person is you can take away a minor's land and you cannot give him then you say he's a minor. When you take away the land, you don't say that he's a minor and did not take his land. If you can take a minor's land, you can might as well grant a minor rehabilitation.
We gave the land in seat of minor, the father or elder brother, family member.
Yes, that is on behalf of the minor.
Behalf of the minor, we gave.
Of the particular acquisition. The father has been granted sometime in 74, 75 acquisition. This acquisition was in
Different.
And there is about 20 years gap in between. So why do you refer back to that rehabilitation in this acquisition?
75.
You should have acquired it all. Each rehabilitation is for one acquisition, isn't it? You cannot acquire by 3 acquisitions and give one rehab plot. That's not permissible. For each acquisition. That's the law. That's what the notification says.
My lord, may kindly, my lord, will clarify that point one.
Yes.
My lord, may your lordship kindly pass an order by clarifying that.
Dictating, please help me if you need further clarification. For learned counsels for the parties.
আমি আর ঘরের বাইরে কি করে যাব?
The grievance of the petitioner is that
ব্যাখ্যাটা করা যাবে অন্য কোনো
আমি করতে পারবো না তো ওর বাইরে আমি যেতে পারছি কোথাও নেই তো সেইখানটাই তো গন্ডগোল আমি নিজেকে বলতে পারছি না
acquired by the state respondents dated LA case number 84/97-98 and he is entitled to a rehabilitation plot in terms of the notification issued by the Government of West Bengal, Land and Land Reforms Department, Land Acquisition Branch, being number 1208-LA within bracket Roman 2 bracket closed. Capital. Roman capital / file number 60-31/89 part PART dated 20th April 1993, the petitioner's request for allotment of such rehabilitation plot was turned down by the authority on the ground that the petitioner was a minor when his plot was acquired and his father was granted a rehabilitation plot previously as legal guardian of the petitioner. The notification dated 20th April 1993 enumerates that persons losing homestead land up to 0.03 acres will be allotted a half plot measuring 0.04 acres, and persons losing more than 0.03 acres will be allotted a full plot measuring 0.04 acres. So what is this half plot and full plot? Both are 0.04. What does it mean? Half plot, full plot? The quantum is the same
Yes.
in both the cases.
Yes.
So what difference does it make? Half plot, full plot?
My lord.
Does it make any sense?
No. My lord, their order, which they have initially granted, page 20 of the writ petition,
Yes.
wherein they have stated.
That is in favor of your father.
Yeah, no, not in my favor. Initially, in my favor, the order was passed. Initially, page 20. My lord, kindly come to the third line. Fourth line, Bastu class of land measuring area of 0.02 acres from the account of petitioner, that is Sambucha, and only 265 square foot structure was occurred. Accordingly, rehabilitation plot measuring an area of 0.04 acre was recommended in the rehabilitation advisory committee. They have recommended that.
And then they decided to.
Yes, yes.
reject. The notification also says that an awardee identified as family should not get any land, as the authority is to take care of family at the time of eviction only. Stop. The term family, inverted comma, quote unquote family, comma, according to the notification, comma, means parents, includes parents, comma, minor children and unmarried daughter. Stop. The plot owned by the petitioner's father was acquired vide LA case number
That is page 34. LA case number.
Page 34 is your LA case.
Impugned order. They have mentioned the case number.
LA case number 09/74-75, and rehabilitation plot was allotted in his favor. Stop. By a separate acquisition proceeding being LA case number 84/97-98, comma, the petitioner's plot was acquired. Stop. Admittedly, the petitioner was a minor at that time. Stop. Paragraph. The notification dated 20th April 1993 does not debar a minor from obtaining a rehabilitation plot in lieu of acquisition of his plot by the state. Stop. The notification says that a family member of an awardee is not entitled to a separate rehabilitation plot. Stop. In the earlier acquisition, the petitioner's father was allotted a rehabilitation plot, and in terms of the notification, no member of his family was entitled to a separate plot in respect of the said acquisition. Stop. The petitioner's land was acquired by a separate acquisition, by a subsequent and separate acquisition proceeding, and has no nexus whatsoever with the earlier proceeding where rehabilitation plot was granted in favor of the petitioner's father. Stop. The petitioner being the recorded owner of the plot acquired vide LA case number 84/97-98, is entitled to a rehabilitation plot measuring 0.04 acres in terms of the notification. Stop. Paragraph. Record reveals that such allotment was recommended by the Rehabilitation Advisory Committee in favor of the petitioner by an order passed on 8th July 2015, and the petitioner was granted liberty to file an application before the Haldia Development Authority for allotment of rehabilitation plot. Stop. Strangely, upon the petitioner submitting such application in terms of the recommendation made by the authority, the application was turned down by the Special Land Acquisition Officer solely on the ground that the petitioner was a minor at the relevant time and rehabilitation plot was allotted to his father, who was his legal guardian. Stop. Paragraph. It is crystal clear from the material on record that the rehabilitation plot was allotted to the petitioner's father for acquisition of his land and not as legal guardian of the petitioner, though the petitioner may have been a member of his family at the relevant time. Stop. Since the plot owned by the petitioner has been acquired subsequently by a separate acquisition proceeding, the petitioner is entitled to a rehabilitation plot in terms of the separate. It is also not understood as to whether, despite recommendation made in favor of the petitioner by the Rehabilitation Advisory Committee and liberty being granted to the petitioner for applying before the Haldia Development Authority for allotment of plot, comma, the you did not apply before the Haldia Development Authority.
No, I have to go through the acquiring authority, means the land acquisition collector.
It was recommended.
My lord.
It was recommended.
Yes.
And after that, you
After that,
granted.
Haldia Development Authority rejected, and on that basis, they again done a hearing. 24/8/15, page 22. They rejected it. And page 23, on the basis of the circular, the authority rejected it. I challenged it before this honorable court. Your lordship passed an order to consider my representation because this circular cannot stand in the way because of a minor. They again considered it on the basis of the same circular, rejected it. So this is the third round of litigation. I came before this honorable.
Also not understood. Why? As to why it is right. For a comma, the authority took a U-turn.
No, my lord.
And
my lord, subject to correction, my lord, can you see page 21? We make decision not to give him as per the direction of the RSC. RSC reviewed the decision.
On the basis of the Haldia Development.
Of that, we U-turn our case. Page 21, the last paragraph.
That's what I'm stating. The authority takes a U-turn and cancels it subsequently.
On basis of the decision of the RSC.
No, RSC has allowed it. Thereafter, they taken a decision HDA. Kindly see the date 18/8/15.
Yes.
8/7/15 in my favor. Then 18th August 15, HDA takes a U-turn that you cannot be given. On thereafter 24/8/15 reviewed, and lastly the reviewed, after reviewing, the impugned order was passed 24/9/15. This is the chronology.
I'm just cutting it short. And chose to reject the request of the turn down the request of the petitioner.
Thank you. 8 seconds. Maybe I'm wrong.
In view of the fact that the land of the petitioner was acquired by a separate acquisition proceeding,
99.
having no connection whatsoever with the earlier proceeding.
Anyway, the
And also,
right was good.
Since the petitioner is entitled to allotment of a rehabilitation plot in terms of the notification, despite being a minor at the time of acquisition of his plot, comma, this court is inclined to hold that the order dated 2nd January 2023 is the final.
My lord.
2nd January 2023 issued by the Special Land Acquisition Officer, Haldia, Purva Medinipur, is devoid of proper grounds and is liable to be rejected. Paragraph. Accordingly, the order dated 2nd January 2023 is liable to be set aside for rejected. Is set aside. Paragraph. The repetition is allowed. Paragraph. The concerned authority being the sixth respondent should allot.
Yes, my lord, and
Only for court.
the Haldia Development Authority. Yes, no, the recommendation is upheld, then the 8th of July 15 is upheld, then only the part remains of the HDA. That, yes. No, the
Question of decision at all.
Point number 6.
The recommendation issued by the Chairman, Rehabilitation Advisory Committee and Additional District Magistrate, Haldia, on 8th July 2015 is affirmed. Paragraph. The sixth respondent, the Chief Executive Officer, Haldia Development Authority, being the sixth respondent herein, is directed to take necessary steps for allotment of rehabilitation plot in favor of the petitioner in terms of the notification dated 20th April 1993 within 2 months.
My lord, and in terms of the recommendation also, 8 July 2015.
And in terms of the notice, the notification dated at the
Actually, it should be in terms of the order of the 8 July 15.
Recommendation dated 8th July 2015 within 6 weeks.
Yes, ma'am.
8 weeks. 8 weeks.
Within 8 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing.
My lord, 8 weeks.
It will be only allotted. You don't require to be heard.
Yes, my lord. I'm sorry. I
The
didn't.
plot.
Yes.
Otherwise, they'll allot it somewhere
Yes,
outside the world.
Yes. I'm sorry, my lord. I didn't get that point. Ma'am.
Upon affording reasonable opportunity of hearing to all concerned, including the petitioner, in accordance with law.
Grateful, ma'am.
After line. When the authority could acquire the plot owned by the petitioner when he was a minor, the authority was also it was also the responsibility of the authority to allot a rehabilitation plot in his favor, despite the fact that he was a minor at that.
Grateful.
You can take away a minor's land and not give a minor.
Yes.
Guideline.
That's the irony, my lord.
Guideline itself not clear, man. The explanation.
It's very clear.
No, the explanation.
I am not falling within that definition also.
Everything is very clear.
Yes.
Only the interpretation. Next.
Grateful.
19.
My lord, in item number 19 to 20, my lord, all the analogous matter, my lord.
My lord, advocate appearing in this matter could not come to the court.
My lord, I filed the report, my lord.
Yes.
So will you come back after vacation?
Yes, my lord.
My lord, one more indulgence, my lord. In this matter, my lord, I want to file a reply, my report, my lord. My lord, on 18th December, my lord, I already fixed the same matters, my lord. So if your lordship can only fix on 18th December, my lord, so that I can file a report. Same matters, my lord. Same issues, my lord.
Report submitted on behalf of the state respondents is taken on record. Paragraph, Learned Counsel for the National Highways Authority of India also seeks to submit a report in the form of affidavit in this matter. Paragraph, the petitioners seek accommodation. Paragraph, let the matter appear under the same heading on 18th December.
Grateful, my lord.
Seventeen to 21.
My lord, 19 to 22.
19 to 22.
My lord.
Same on-
20, I am paid for my lord. Item 20.
Yes, Ms. Mukherjee?
20 for the state. Only on item 20.
You're not audible. Your
Am
voice
I
is
audible now? Sure. Am I
You're
audible?
for the state in which matters?
Item 20, my lord.
21, my lord. She is
21.
20.
Yes.
21 তুমি কি করে
Item 20.
Yes.
Item 20, my lord.
You are not audible, madam. I'm sorry.
20, my lord. Item 20. I have
for state.
my lord.
Is 20 for state.
20. Item number 20.
Yes, my lord.
Yes.
In other matters, Mr. Dey is appearing.
Yes, my lord.
No,
My lord. Audible.
22 I am for this.
তাহলে শুধু on prayer of the petitioner the matter is adjourned. বলে 18th. Report নেই কিন্তু।
my lord, the report portion should be there, my lord, on my part. Otherwise, my lord, I cannot be.
Stated report নেই কোনো। Learned Counsel Oh, you have reports in the other matters also. Oh, he has.
My lord, item number
এটাই না পরেরটা 21 এটা 20
19 আছে।
Learned Counsel
19 দিলাম তো।
and 20 on prayer of the petitioner the matter is adjourned. Learned Counsel for the NHAI seeks to submit a report in the form of affidavit in this matter. Let the matter appear under the same heading. 21 same as 19.
Yes, ma'am.
Stated report আছে NHAI file.
22 আপনি আছেন।
22 my lord are for this case.
You have a report?
Yes, madam. No, no.
No.
That's fine.
On prayer of the petitioner, the matter is adjourned. Learned Counsel for the NHAI seeks to submit a report in the form of affidavit in this matter. Let the matter appear at the same heading. Same. Next, 23.
I'm for the state lordship, Mutha Pajamon.
For HDA.
You're for
Development authority.
HD.
My lord, Holla development. Holla development.
Petitioner, anyone?
Lordship.
Petitioner. No one. None appears for the petitioner. Let the matter appear under the same heading on 12th January 2024.
In 24, my lord, I appear for the petitioner.
Lordship,
In terms of your lordship's direction passed on 18th September 2023, they, my lord, served as a copy of the report. We want to file, my lord, exception to this, my lord.
You're filing your report today?
Lordship, Mr. Arun Banerjee appearing for the state. I'm also appearing for the state led by Mr. Arun Banerjee. Lordship, kindly bring for not today.
Where is your report?
Report of file,
Report is not.
copy has been served on us.
It's not on record.
It's not.
It is in the form of affidavit.
Report only.
It's
Bring
not
for
with you?
no, Lordship. Bring for only not today, Lordship.
My lord, your lordship kindly direct us to file reply, affidavit reply, because it is in the form of affidavit. And the direction may kindly be given, my lord, to the state respondent to supply us copy of the lease deed, which is, my lord, given to the
The state comes, she is not aware of the matter at all, I'm sure. On prayer of the state respondents, the matter is adjourned. Paragraph. Learned Counsel for the petitioner seeks to use an exception to the report in the form of affidavit, comma, copy of which has been made over to learned counsel. Stop. Let the matter appear under the same heading on 14th December.
Lease deed copy to change. Lease deed copy একটা আছে আপনার কাছে আছে?
Yes, yes, Lordship.
In the report,
Hello, the report, my lord, they have referred to a lease deed which has been given to the private respondent.
Not on record. Let them come back.
For the petition.
I'm for this petitioner.
I'm for the
petition. Yes.
The matter pertains to my land being enrolled as a walk-up property, despite the inquiry report submitted in this regard, stating that
Your land has been encroached as?
Enrolled as a walk-up property, despite the fact that the inquiry reports describe all the documents standing in my name, the property starting from CS record or ILR record. Despite the said fact, the inquiry was made. In the inquiry report, it has been specifically stated. It was a kindly take trouble to look to,
Can this court deal with Waqf property?
The
determination? I don't think so.
determination is not there. Determination nahi. Walk-up.
Will you please find out and come back?
I will come.
Yes, Mr. De?
Yes, my lord, I'll see.
No, my lord, it's walk-ups. My lord, walk-up.
Shantanu? Waqf property কোন bench নিচ্ছে দেখুন? কোন bench নিচ্ছে দেখুন তো determination?
If it comes within the purview of land, then certainly you are.
Yes, because I don't deal with Waqf property matters.
In that case,
Land, but it is Waqf property, so
then I will check it up, I will
it's fine. Please check and come back because I have to doubt about it. Shall I make it not today only?
Yes, ma'am.
Not today. একটু দেখে নিন তো বা একটু জিজ্ঞেস করুন সম্রাটকে জিজ্ঞেস করুন দেখুন not today. Affidavit of evidence.
My affidavit service file not kept.
You can give it back on the next day. Start with the petitioner, but the petitioner has died, Lordship. Petitioner has died. File. You have to substitute. Submitted on behalf of the petitioner that the petitioner has expired. Stop. Learned counsel seeks to take necessary steps in this regard. Paragraph is going to go out of this. File your application and come back. Did
Senior Advocate Mr. Vikas Ranjan Bhattacharya and Mr. Saurabh Thakurata is appearing for the respondent. My lord, kindly fix this on Monday. Tuesday.
Monday is a holiday. I will not come to court.
Tuesday. My lord, I am extremely sorry. Tuesday.
This matter may be fixed after the vacation, Your Lord.
You are appearing for the
petitioner, Your Lord.
No.
A joint meeting was held between you.
Lordship, a joint
for an amicable settlement.
Lordship, in the this is with respect to the Your Lordship, the proceedings which was happening before the Metro Authority.
Yes, yes.
Lordship, that happened, but thereafter the order has been passed, Your Lord, as relevant documents were not enclosed at the time of hearing. Also, Your Lordship, also with the order.
After that, the authority submitted that a joint discussion was
after
being
that,
held.
Your Lordship. It was earlier, Your Lordship. Not
After that, nothing has happened.
No, Your Lordship.
I think report was been submitted on the last occasion, my lord. Report which was supposed to be filed, it was served on the last, it was filed on the last occasion, Lordship.
Received the report? Lordship, we have received a report. Lordship, as per your Lordship's order dated 23rd February 2022, your Lordship, there was a direction upon them that the learned counsel appearing for the respondent number 2 seeks to file a short report annexing.
Yeah, it was filed on the last occasion, Lordship. That
The
is
report
fine.
has been filed, your Lordship, but no relevant documents were enclosed. However, we shall come back on this, Lordship.
Because the meetings of the mediation, it was enclosed with that report itself.
Come back.
It's only the
Yes.
On prayer of you're for the second respondent.
Yes, we are for the Railway Authority and the Union of India.
On prayer of the respondents, the matter is.
1 and 2.
Who is appearing for the other respondents? So that we can take up the matter on the next occasion.
Lordship,
That is the Metro Authority. That's all.
Tuesday will not be possible. Come back on 4th December.
4th December. My lord. Grateful, your Lordship.
I am for the Union of India, led by Mr. Nilanjan Bhatt.
28, all reports have been filed, exceptions have been made. It's for hearing. Mr. Shokinath Mukherjee is appearing for the petitioner. He is unwell, my lord. Kindly make it after vacation, my lord.
After vacation.
My lord,
Petitioner, yes.
my lord, I'm for the state respondents. I'm being led by Mr. Talib Siddiqui. He has instructed me to attach this matter if possible, Lalit Khaitan WPA 18151 along with this matter. A similar matter.
Yes.
এখন তালে আছে কোথায় না বললো তো তালে that is their problem.
The court will not go into this.
আচ্ছা interim order is till 30th.
I find Mr. Bandyopadhyay's name recorded.
He was appearing
All throughout, Mr.
Yes,
Bandyopadhyay's
madam.
name is recorded. On prayer of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 15 January.
interim order be extended till 30th.
Paragraph, the interim order granted earlier is extended till 31st January or until
Obliged.
further orders,
Obliged.
comma, whichever is earlier.
Obliged.
Time for the petitioner.
Petitioner is.
Your Lordship, I beg to appear on behalf of the respondent ECL authorities led by Mr. Syed Noorul Arifin, Your Lordship. On the earlier occasion, Your Lordship, on earlier occasion, Lordship directed to file a report in the form of an affidavit. Your Lordship, I'm praying for 4 weeks time, Your Lordship.
Your
for the
Lordship,
extension of time.
Your Lordship is of the opinion that the matter will be disposed of at the first instance, my lord, directing them to consider their representation.
Your Lordship,
My lord, they insisted on, my lord, me filing a supplementary affidavit. I did that. They insisted on, my lord, them filing a report, my lord.
Your Lordship, since
That insistence was fine, but this insistence is not correct. They are insisting for time now.
My lord, that is the whole matter.
My lord, I am for Union of India. Yes, madam.
Your Lordship, since we have applied for the certified copy, Your Lordship, it's taking some. The petitioners challenged the ownership of the ECL authorities, Your Lordship. We have applied for the certified copies, and
My lord, we have
that is
stated
taking
that
some time, Your
out of
Lordship. It's a
48
time-consuming
decimal,
process.
out of 48 decimal, 4th decimal has been acquired, but they are using the remaining 44 decimal as well. And my lord, therefore, my lord, I should be paid my compensation. Along with that, my lord, there was a job scheme. These are, my lord,
Consider the representation of the petitioner.
Kindly extend for, kindly give us for. Not today, Your Lordship. Your Lordship, kindly give us for 2 weeks time, Your Lordship, for filing the report in the form of.
Your lordship, whatever your
Kindly.
lordship is.
No, come back before.
There are other instances, my lord, I have to be on the same foot, my lord, I cannot oppose that prayer.
December.
Lordship.
On prayer of the ECL, the matter is adjourned. Report or no report, it will be considered on the next date. Let the matter appear under the same heading on 15th December.
Much obliged, Lordship.
Next. Our actor ticket.
No,
I'm for the added respondent in this matter.
Metro Rail, my lord, I was
My lord,
granted
I'm
leave
for the respondent number 2, my lord. My lord, just now I have received the copy of one reply, my lord, and in this matter I am led by London ASG, my lord. My lord, due to his back pain, he has not able to come, my lord. So let the matter may be fixed on, my lord, taken about
Reply
30
by the
by the Metro
by
Rail.
the respondent number 4.
reply by the petition.
No. My learned friend filed a supplementary affidavit, my lord, and I was granted time to, my lord, to granted leave to file this affidavit, which I have done within the time. I have served the copies to the others also.
Lord, just now we have been served, your Lordship.
So you want to come back?
Yes, Lordship. Do some.
My lord, so far the supplementary if it is concerned, my lord, I will.
Owner and tenant issue?
Yes, my lord, I will not use any reply in the sense, my lord, whether a written submission can be taken into consideration for the purpose of disposal of any matter, wherein there was no specific pleading in the objection, as well as no evidence was laid by the applicant, adduced by the applicant. So therefore, there was no scope for the competent authority to decide that issue. Now, by way of the supplementary is nothing, but they are saying that we raised the objection that there was no such pleadings pertinent to their allegation that this was done for the Nepal Constitution.
This has been explained in my affidavit.
Have you received?
Now, my lord, the worst sufferer is myself as well as the Metro Rail Authority, because of this they cannot proceed it further. I understand. It would,
That is one part.
but my claim. Under section 13. Sir, you have not been properly instructed. আমার ক্লেমটাই এখনো ডিসাইড না অ্যাপিল করব কি করে?
Reply to supplementary affidavit submitted on behalf of the fourth respondent is taken on record. Paragraph, copy of the said reply is made over to learned counsels for the other parties in court this day. Paragraph on prayer of the petitioners. You're asking for some time. The matter is adjourned. Petitioners and respondent number 2 also. You're also asking.
We have also just received
On
the
prayer
copy of the reply.
petitioners and the second respondent, the matter is adjourned. After vacation.
Kindly make it
not that late.
not 30 or thereafter any day.
Not that late, Lord. First week of November should be there, because this should be disposed of. It has been hanging on for a long time. We are
Let the matter appear. Yes, I know it should be disposed of, and that.
Yes, Madam, this is public
yes,
interest is involved. Public purpose is involved.
I am not praying any longer time. Kindly fix it first week of December. If it's my Lord guide him,
Let
Lord.
the matter appear under the
Dispose
same
of.
heading on 12th December.
Kindly make it at the fairly at the top, my lord, because this is my honest request, because I am the worst sufferer in this, my lord. I am the worst sufferer in this.
2022 matter. Because it appears chronologically now.
So for the compensation part is concerned, Lord, I will ask the gentleman who is dealing it within the time and give a lot of the exact picture. But I was told there is an appeal pending. It cannot be decided now.
Please take necessary instructions.
I will do that, Lord.
Please take steps for clearing the compensation.
I will do that. I will do that.
Man should be suffering unnecessarily.
I will come back with.
He's made over his property. He has no objection. He has cooperated with you.
I will
but
come.
you have not paid the compensation.
I will come back to your lordship with proper instructions and the real picture I shall show to your lordship.
And I expect your submission on the next occasion that compensation has been paid.
Lord, that I cannot.
If there is no dispute with regard to that, then
So
why
far,
will it be
so far
withheld?
as a lawyer, I would say if there is no dispute, it should be paid.
Yes,
But what I am saying
please
in court,
instruct your clients accordingly.
I have already done it.
One cannot be made to suffer for the.
Kindly don't take me amiss that I didn't do what I hear
There's
today.
no question, but please give necessary instructions.
I'll do.
Yes, next one.
My lord, before my lord takes up the
Mention matters.
mentioned matters,
Yes.
my lord, I have very innocuous prayer. My lord, so far I said item number 35 is concerned. That may not be taken up by your lordship because
I have not called as yet, sir. Please don't do this. Please come back when it is called.
as
Yes, 427.
My lord, I am for the petitioner, my lord.
Mr. Bandyopadhyay. Service upon all the respondents is complete. It was not complete on the earlier date.
My lord, probably my lord, that was my lord handed over to your lord
Private respondents.
on the last occasion.
Yes, on the last occasion.
My lord, yesterday it was taken up, my lord. My lord, I've got a photocopy, my lord. It shows complete, my lord.
Yes.
Yesterday there was a not. It was a not.
Not today, my lord.
Not today, my lord.
It was not.
I have taken adjournment, my lord, that is brief also.
If I may just interrupt.
Yes.
So for the compensation under the first notification is concerned, my client is here, check is ready, maybe within the next week it will handle.
Mr.
That's why I have said that the payment has not been made.
I didn't deny.
Please collect the check.
My lord,
It's ready.
I will.
I didn't deny. I
That,
didn't deny.
that settles one part.
That is one part of it. That's it.
Affidavit.
My lord, I've got a photocopy, my lord, of the affidavit of service, my lord. Yes,
It's original. It's not there on.
my lord. Yesterday, my lord, when it was taken, my lord, I probably handed over.
Please show the. Yesterday it was made not today. So affidavit could not have been given.
Yes, my lord. Normally, that is not the practice, my lord.
I'll just find out.
My lord, it is otherwise served, my lord. I've got a photocopy, my lord. It can be, my lord.
All of them?
Yes, my lord.
You've checked yourself? All four of them?
My lord, not all four. 2 has been delivery confirmed. 2 dispatched to BO. That is the difficulty, my lord.
Thank you for apprising.
Yes,
he has to come back. Since service upon all the private respondents is not complete, comma, let the matter stand over till 20th.
20th, my lord, I'll come back, my lord. But my lord, only difficulty is, my lord, there is a notice hanging over me, my lord, that it will be demolished. My lord. My lord, that undertaking we recorded, my lord.
I'm not taking it away. See, why need to
10-3.
My lord.
What notice? 10,
10-3. 10-3. Well, there's some, my lord, there's something to show before your lordship, my lord, that an order has been passed by the DLRO, my lord, violating an order of this honorable court, my lord. A specific direction was there, my lord, for another authority to consider my prayer, my lord. And my lord, that has been, my lord, violated, and the DLRO has taken up the matter on his own and passed an order.
That could not have been done. Prima facie.
My lord's direction was, my lord, before over the, my lord, director of land records and survey. But the hearing is taken by the district land and then.
That cannot be done.
My lord, I have to take instruction to that effect.
Please come back. Please come. 20th December. Cool. 20th December.
My lord, anything, my lord, any order be recorded, my lord. My lord, otherwise, my lord.
Can you serve earlier? Can you serve by 8th December?
8th December I can do.
Can serve?
I'll do it.
Bashu, 8th December. Complete service.
My lord, my lord. Grateful.
For 28, my lord, I am for the petition.
And I'm appealing for the statement.
I have served. Yes. This is my affidavit of service. Lord, I beg to leave to file my supplementary affidavit.
Supplementary affidavit.
Yes.
Have you served?
Yes. Yes, madam. What happened in this matter relates to unauthorized enforcement of public land. That is the land of a school.
Served the private respondents?
Yes, ma'am.
All of them?
Yes. They have received
Give me a minute, please.
item delivery confirmed.
Fifteen of them.
Service copy affidavit service.
Yes.
This matter relates to unauthorized enforcement of public land, that is the land of a school, and the petitioner raised objections before the various authorities, including the subdivisional officer, to remove the said enforcement. Otherwise, they are unable to make further construction. In the meantime, during the pendency of the writ petition, the Sarva Shiksha Mission granted fund for construction of toilet that I have annexed with the supplementary affidavit. That is at page 7, my lord.
Yes.
May I read, my lord?
No, I've seen it. Yes.
And that is serial number 72. Next page, page 8.
Yes.
Bhogpur Primary School, number of additional girls toilet unit sanctioned 1. But the petitioner could not able to make construction due to enforcement. The petitioner raised objections, but the respondent authority took.
So the school's land is encroached,
Yes,
not the government land.
that is public land. That is school is come within the definition of section 2(7). That is public land of the Unauthorized Occupation Act 1962. And on the basis of representation, the chairman wrote a letter to the authorities. That is at page 28, 29.
Where is your representation?
It starts from page 31. Page 31, relevant representation, what I am praying, kindly direct the subdivisional officer. That is at page 37.
This is to the Pradhan. Pradhan will not.
No, page 37, page 37, my lord.
Well, difficulty is this, the demarcation was done by the village education committee, my lord. That ought to have been done by VLRO, my lord. Otherwise, it's very difficult.
Consider the representation. Yes, consider করে সেইটা ব্যবস্থা নেব.
There is a representation, my lord. Kindly direct the representation to be considered, my lord.
The SDO should consider.
That is page 37. Page 37.
Let the SDO consider this.
Yes, yes, my lord. SDO is the respondent number. My lord, 5.
Affidavit of service and supplementary affidavit submitted on behalf of the petitioner.
My lord, district magistrate.
None.
SDO is the one.
SDO is the authority. Unauthorized occupation act.
Not taken on record. Paragraph, none appears for the private respondents despite service. Paragraph, the petitioners allege, the petitioners who are the petitioners?
Headmaster, headmaster and president. Headmaster and president.
Where is stated headmaster and president?
That is petitioner number 1 is the head teacher. It will find from the representation. That is page 37. Page 37. Serial number 2. Head teacher. and serial number 1, president of the school. That is petitioner number 2 herein.
Your writ petition says paragraph 6, the petitioners are members of the village education committee.
Including the head
The
teacher.
litigation in
No,
that.
no, including the head teacher. Head teacher made it.
One, the writ petition.
Paragraph number 3. Paragraph number 3.
Yes.
Your petitioner states that the Bhogpur Board Primary School is the riot in respect of the land situated at plot number so and so, Mauja so and so, district herein after referred to as the said land. And the petitioner number 1 is the head teacher of the said school situated on the above mentioned land. And your petitioner further state that the school has been paying regular revenue in respect of the land situated at plot number so and so, district Purbo Medinipur. The head teacher along with the members of the village education committee filed this writ petition because they jointly made representation.
No, the first petitioner, who is the head teacher of Bhogpur Board GHOG, Bhogpur Board Primary School, comma, along with the other petitioners, allege that the private respondents have encroached upon government land adjoining the school by raising unauthorized construction therein, comma, thereby obstructing the smooth functioning of the school,
And also make construction.
as well as construction of ladies' toilet proposed to be
Supplementary to the supplementary.
made by the school in terms of administrative approval granted by the additional district magistrate within bracket development bracket closed comma Purbo Medinipur. The petitioners submitted a representation before the concerned authority on 16th August 2022, which is yet to be considered. Stop the petitioners, pray for a direction upon the authority to consider the representation at the earliest. Paragraph is submitted on behalf of the state respondents that the
Respondent number 5.
fifth respondent be directed to consider the representation in accordance with law.
In terms of the provision of the Unauthorized Occupation Act, 19.
Paragraph in view of the above, comma, the petition is disposed of, directing the fifth respondent to consider and dispose of the representation submitted by the petitioners dated such and such, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners and the private respondents, comma, in accordance with law.
Within Milad.
Within 3 months. Or upon affording an
3 months.
within 3 months from the date of communication of this order.
And communicate the decision to the district.
The state is there.
Council also there. Also.
Mr. Devangsu Ghoroi is a petitioner, not today. He engaged code number 28.
Code 29 তুমি আছো?
Code 28.
28 শেষ হয়ে যাচ্ছে।
3 months this over 3 months.
সোজা হয়ে যাচ্ছে।
দিয়ে দিয়েছি হ্যাঁ নাম
After vacation. Yes.
After
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 9th January.
তো কাউন্সিলের নামটা দিয়েছিস?
4:30 I appear on behalf of the petitioner. This is the service. But this is a matter the petitioner was made application 19 respondents my learned when is appearing.
So, this is appearing in this one.
But in 1995, petitioners made application for long-term lease for extraction of sand. No steps was taken, writ petition was moved. Order was passed disposing the writ petition, directing twofold. One, to dispose of the application within certain period, 8 weeks. And in the meantime, petitioners should be allowed to extraction of sand upon issuing the royalty, upon receiving the royalty. Query permit were received, it was continued, then subsequently it has been stopped. Petitioner raised objection, nothing has been done, writ petition moved. Then a reason order shows before the court, no opportunity was given. Ultimately, writ petition were allowed, directing them to take a fresh decision upon giving opportunity to the hearing. Now that writ petition was that reason order challenge before my lord. My lord has been pleased to dispose of the writ petition, previous writ petition, but the dealing everything, because there are two grounds they have taken. One, in 1995, there is an order that I have to communicate the order within 2 weeks. My lord has satisfied and my lord rejected that condition. And second point they have taken that in the meantime, since 2016 rules has been came up, so I am not entitled. Now my lord's order last order kindly see at page 58, order dated 20th of April 2023. Pursuant to this, reason order has been passed. I have challenged that. Now kindly see my lord's order. Now my lord's page 58, second paragraph. It is submitted on behalf of the petitioners that the petitioners submitted an application for grant of mining lease before the concerned authority in the year 1995, which was not considered by the authority, for which the petitioners came up before this court in a writ petition being civil order number such and such. By an order dated such and such, the court disposed of the writ petition, directing the authority to dispose of the application filed by the petitioner in accordance with law within 8 weeks from the date of communication of the order, which was to be communicated by the petitioners within 2 weeks from the date of communication, from the date of that order. The court further directed the authority not to take recourse of Rule 7(7)(a) of the minors minerals rules in disposing the application. In the meantime, second part I am coming. In the meantime, the petitioners was allowed to extract sand gravels from the land in questions on payment of royalty to be assessed by the authority. In terms of the said order, the petitioner continuing mining operations upon payment of royalty. Now, the application filed by the petitioner was considered and rejected by the authority by an order dated 20th November 2018, against which the petitioners further moved a writ petition being WPA number such and such. By an order dated 7th January 2019, a coordinated bench of this court directed fresh hearing of the applications solely on the ground of reasonable opportunity of hearing not being afforded to the petitioner. In compliance with the said order, the authority passed the impugned order, which is assailed in the writ petition. The application of the petitioner has been rejected by the concerned authority on 2 grounds that I have said. But firstly, since the petitioner did not serve copy of the earlier order of this court to the authority in a compliance with the direction of the court, and secondly, the petitioner's application could not be entertained in view of the Rule 61 and 62 of the West Bengal Minors Mineral Concession Rules 2016, read with Rule 40 of the West Bengal Minors Minerals Rules Rule 2002. It is submitted on behalf of the petitioners that since the applications was made in the year 1995, West Bengal Minors Minerals Rules 1973 was in force. The said rule shall apply to the case of the petitioner and not the subsequent rules of 2002 and 2016. And the Council for the State denies and disputes such contention of the petitioner. It appears from the documents produced by the petitioners that copy of the earlier order of this court was duly communicated by the petitioners to the authority. Also, the order impugned be bereft of any reasoning with regard to the scope of entertaining the application in terms of earlier and existing rules. Learned Counsel for the state respondents also submits that the matter may be remanded to the concerned authority for consideration. In view of the above, the order impugned passed on 5th March 2019 by the Additional District Magistrate, District Land and Land Reforms Officer, Paschim Mendipur is set aside. The concerned authority, being the third respondent herein, is directed to revisit the application and pass a reason order and speaking order upon considering the submission made on behalf of the petitioner, his authorized representative, as well as the provisions laid down in Rule 61-62 of 2016 rules and Rule 40 of 2002. The authority is directed to communicate. This was the order passed by my lord. They have asked me to appear for hearing. I have appeared on 12th of May 2023. My lord, I appeared before the hearing. I have submitted the written notes of argument, page 63 and onwards. Every documents I have shown. Even then, my lord, they have passed a reason order which is challenged in the petitions, in this writ petition at page 75. This order was communicated, can you see, 12th May matter was heard. But this was communicated in the month of August, 25th, the 16th of August 2023. Lordships kindly come, the order number 2, 12th May 2023.
Yes.
Page, relevant page, page kindly come, page 676. In the course of hearing, the petitioner submitted a written notes of argument which is also taken into consideration. The main issue to be taken into consideration are, they have framed this issue. Number one, the petitioners claim to have submitted an application for granting LTML, long-term mining lease, which has not been considered. Second, the application is to be revisit considering submission made on behalf of the petitioners, his authorized persons, as well as the previous provisions laid down in Rule 61-62 West Bengal Minors Rules 2016 and Rule 40 of 2002 rules. Third, the applications was made in the year 1995 and should it be considered as per West Bengal Minors Rules 1973? Well, this is the last point they have taken. Now, they have elaborated. The fact is, the petitioner claimed to have submitted an application for granting mining lease for minor minerals, sand and gravels in terms of Form A addressing to the Secretary, Commerce and Industry Department, Mines and Branch, Writers Building, Calcutta. 1. Another copy of Form C addressing to the copy signing mining lease officer, officer in charge, Purulia Zone. Purulia Zone was annexed in the writ petition, who is not a party in the respondents. So can it be said his subordinate officer, ADM, is taking a decision? He says his subordinate officer is not a party. Then, but during hearing, no such original receipt copy of which the office seal and receipt signature of the office concerned with the thereupon has been able to submit by the petitioner. Absolutely incorrect statement. But today I have the copy, even receipts. I have annexed the documents here. I can show, my lord, but it is at page. Lordships kindly come. I am showing this. Application page 29. Page 29, application start. 30 is the end of the application. Page 31, the receipt, money receipt. And 32 is the receipt acknowledgement of the application. Now, only, my lord, I am showing one, the page 30, lordships kindly come. Serial number 20, 21 and 22. These will, they will come on this point. That's why I am saying.
32 receipt কোথায়?
32 is the receipt. Receipt issued by the authority. This has been issued in my favor. They have accepted original documents with me. Now, 20, serial number 20, what the number and dates of income tax, number and date of income tax clearance certificate from the ITO. 21, number and date of clearance certificate of the mining dues. And number 22 is the sale tax clearance.
Or enclosed.
They are taking these points now. That's why I'm showing here. So once page 32, they have issued a original receipt in my favor. They have accepted. They have seen those documents. Now, Lordships, kindly come. The petitioners thereby cannot hold any right to do sand mining without his lease deed or quarry permit or license as admitted and granted by the competent authority. But I have annexed the documents. I have the original documents in respect of the query, but they have issued in my favor upon receipt the royalty pursuant to the order of 1995. I have also annexed the Xerox copy.
Short-term license, is it?
Short-term, pursuant to the order of the court.
Pendency of the
Yes, he said. Because of that, my contention is the order has been partly complied with. Action has been taken. Now, nor any copy of the acknowledgement of receipt of the application form grant any right to the petitioner to mines and sand from the land in questions noted in the margin alongside. Hence, the claim of the long-term mining lease in this regard is not admissible. This is a technical ground they are taking. I have the documents. I have annexed the document. They are saying this. Next point. No application in specific has been submitted by the petitioner after order of the Honorable High Court, Calcutta was passed in connection with the W. Is it necessary at all? Why they are saying this? No, their contention, until and unless you get the mandatory order from the Honorable Court, we will not issue the order.
Before you proceed further,
Now-
will you come back with instructions?
Yes, ma'am.
Because he needs to come back with a report.
I have specifically dealt with each and every point in paragraph number 14 and onwards. Let the direction be issued by my learned friend to take instruction on that. All these points they have taken. Absolutely frivolous ground they have taken, and I am suffering. This is the 5th time litigation. I compelled to move before this Honorable Court. And only then they are saying that the rule 2016 and 2002 has been came into effect. How it can be? Here rule 22, if your lordship goes through, the rule 2002 specifically held that there is a saving clause. Rule 14, rule 4040. Any action taken, if it is the earlier rule, it has been saved. Since they have issued, they have received the royalty upon issuing the quarry permit, order has been activated, steps has been taken. Once steps has been taken, so that has been saved. And second, but sir,
62 act minute, only act minute. 62 of the minus has been rule. Then there is a provision of appeal. Then this petition is not maintainable.
Order is there. Honorable High Court's order is there.
That is not clear. If my lord he challenged that portion, then my lord 51 is barred. Rule 51.
Cannot be.
That is the provision of appeal.
95 High Court's order is there. So long High Court order is there, it has to be carried out. Even if it is wrong, it has to be carried out. They cannot say at this stage after 20 years or 25 years that there is a provision. This cannot be. High Court's order cannot be evaporated alone.
My lord, according to the provision of 51 of the
High Court's direction was reconsideration.
For consideration of the application in terms of in accordance with the law. What is the law there? 73 rules is there. It has to be considered in terms of 72 rules.
So they has a point. High Court's direction was consideration of the application.
Yes.
Along with under 62 and
Yes.
73 rules.
Consideration that
73 rules.
2016, 73, 2002 and 2016 rules. It was considered, you came back before the High Court, the High Court directed a reconsideration.
Yes.
Yes. So if you are not happy with the order now, it has to go back for appeal.
No. Kindly consider this situation.
Challenge the merits.
Kindly consider. So that at least 4 times order has been passed by the Honorable Court to consider the application.
Yes.
Now,
the
first order.
Consider the application. Not
Yes.
the
Consider the application means the contents of the application. Consider the application not like ABCD, whatever may be. Whatever they think, that is not the way. Guideline has been framed in accordance with law and what is the contents of the application, it has to be considered. Now, 95 order specifically spelled out that you have to consider within 8 weeks, as I have shown from my lord's order recorded there, page I have annexed here also, in accordance with the law. Now, 95, what law is there? 1973 rule was applicable.
So you are on merits.
My lord?
You are on merits of the application.
Yes, I have the merits. They cannot say today that 2002 rule is effect.
On merits before this court when there is a provision for appeal.
No, no provision cannot be applicable.
Why? Why cannot it? Because you are challenging the order on merits.
Well, they have said my application cannot be considered in terms of the grounds they have taken. These are not at all relevant grounds, and they said that 2002 and 2016 rule came into effect.
In other words, you are challenging the application, the order on merits.
Yes.
Not on a technical ground.
Now, kindly see, consider on what basis they have passed the order. They say application cannot be considered in terms of 16 rule and 2002 rule. Now, rule applicable 973. 73 rule is applicable. Is there any provision for appeal? And the High Court says to consider the application. This is the first time they took this point. Now, Rule 40, lordships, kindly come. Rule 40 of 2002, what does it say?
They have considered it under the
My lord, if your lordship will come 59.
page 59.
Yes, my lord.
They have considered it under the 73 rules.
No, my lord. Your lordship's order was there.
59, yes.
59, my lord. Last but before one. Firstly, since the petitioner did not serve copy of the earlier order of this court to the authority in compliance with the direction of the court. Secondly, my lord, writ petitioner application could not be entertained in view of the rule 61 and 62 of the West Bengal Minor Mineral Concession.
The earlier
This is the ground they have taken.
This is the earlier ground of rejection against which the petitioner preferred.
Yes, my lord. For that is, my lord, you sent the matter, return back to the for those two grounds. My lord, your lordship, return back. And after it is submitted on behalf of the petitioner that the since the application was made in the year 1955 or
95.
Western Minor 73 was in force, the rule shall apply to case of the petitioner and not the subsequent rules of 202 of the Act. Well, that is the 2 points is that, well, the 1 point is rule 61 and 62.
Huh?
For that is, my lord, that point, my lord, he must file appeal.
No.
61, 62?
This is under the 73 rules.
In spite of that,
considered.
Then, my lord,
Please come to page 77. The penultimate paragraph. The application made in 1995 being considered under West Bengal Minor Mineral Rules 1973 is not accepted either.
Yes, my lord.
This is the reason. How this can be?
My lord, before that, my lord, that is first paragraph. That starts clearance of certificate of payment of ATO 1973, but no documented evidence in terms of proper received copy bearing mandated annexure accompanied by this application is application submitted and exhibited by the petitioner. In addition to, as per Rule 2 of 62, West Bengal Minor Mineral Concession Rule, West Bengal Minor Mineral Rule ATO has been repealed, which came into force on 8/1/82. As a matter of
Repeal
fact,
saving
the
clause is there, right has been protected. In 2 rules, I have said.
Then, my lord, I could
I
file
think
a
a report is necessary
yes, my lord.
clarifying these.
Yes, yes, yes.
The order passed by the Additional District Magistrate and District Land and Land Reforms Officer, Paschim Medinipur, on 12th May 2023 is assailed in the writ petition. Primarily on the ground that the order does not consider the documents placed by the petitioner before the authority and is also faulty on factual aspects. Paragraph Learned Counsel for the state respondents seeks to submit a report in the form of affidavit in this regard. To the affidavit of service. Then. Paragraph, let the matter appear under the same heading
Mention.
after vacation.
Yes, my lord.
Prior to that, this
আরে করা যাবে না একদিনের মধ্যে
মেদিনীপুর তো
মেদিনীপুর হলো ছিল এভিটিংটা তো মাই লর্ড আফটার ভ্যাকেশন
আপনার ভ্যাকেশন এতদিন কেন ছিল এই ভ্যাকেশনের আগে আরেকটা নাও না কি
না যেটা পারবো না
First week after.
prior to the vacation any day.
First week after opening, 5th.
Today we are at the end of 24th of November, so it can be the 3 weeks they can come.
কাম হলে বলে দিতাম তো তোমার আরে এটা লিখতে হয় ভালো করে বোঝো না
Come back on 5th January. 5th January 2020.
বছর পার করে দিলে
Mr. Dev, please serve an advance call.
Yes, ma'am.
hello 5th January supplement 5th January কি ইয়ে আছে না মান্থলি না তো ফ্রাইডে আজি না স্যার
For 31, my lord, I am appearing on behalf of the state respondents. Along with Mr. Mansura.
Kindly see Lordship's order, page 22, annexure P1. Pursuant to Lordship's direction, my lord, the physical verification, joint field verification has been done, annexure page 25. Thereafter, my lord, the prayer for compensation has not been considered. I beg to apologize, my lord, kindly appreciate to that.
Joint verification was done.
Done. Thereafter, my lord, I made the representation after the joint field verification. My lord, I made the prayer for before Lordship's page 30 in terms of the order earlier. Sorry, my lord, the page 35. The similar order has been passed Justice Banerjee or the Banerjee relating to the payments procedure relating to the purchase by purchase. But I prayed for my similar order we passed. Only, my lord, clarification. My lord, during pending of the case, my lord, the special land acquisition officer has already considered the things during pending of the proceedings case. Justice Arijit Banerjee has passed the order. Other matters. This has been tested before the division bench. Division bench, my lord, the rejected. Thereafter, my lord, the contempt application pending. Payment has been done. And this matter relating to this, my lord, pending before this read application, not the special land acquisition already passed an order.
In this matter.
In this matter also. All the other matters also. All the hearing token. So direction me, my lord, the given to the purchase committee. So far my instruction, my lord, the collector is the chairman of the purchase committee.
Without taking instruction, people
Huh?
My lord, there are so many matters there, my lord.
Okay.
Without taking instruction, my lord, it
Key
is not
instruction,
possible
you've already order passed.
to pass that order, through that order. As because, my lord, there is direct order to purchase.
That was just.
So, my lord, we must take the instruction.
Oh, that order not, that
There
is.
is, my lord, there are so many 13 or 14.
The
15 matters.
acquisition officer's memo also says so. Direct purchase.
Yes.
My lord, that is in his case for the petitioner. That we must know that. After that, my lord, that is a mandatory order is there.
No, this is a communication to me. This is communication to me.
Communicated to the.
I mean, sir, please give
Here and now.
their copy.
This is communication to me. Communication to me.
In spite of that, my lord, we must take the instruction. Otherwise, my lord, it is a very direct purchase matter, my lord.
Direct purchase, my lord, this is the direct purchase and other matters.
Contempt. For that reason, my lord, we must take the instruction first.
Let them come back with instruction.
No, this is, my lord,
Not
kindly see, this is the other matters. This is other matters.
Every
I
matter
prayed
is there,
for
my lord.
a similar order should be passed.
State can ask for instructions.
The
isn't
state
it?
already passed the order. Kindly appreciate to that.
My lord,
Can the court stop the state from coming back with instructions?
No, I am not such a way.
Then
What's instruction will be
let them
more?
come back, I'll fix a short date.
Then your lordships, all the matters we will
When are the other matters fixed?
similar. Other matters, my lord, the
Oh,
432.
these are all your matters.
All in 15 matters are there.
I am appearing on
And the
438.
single order will cover all the.
Of course. 432, 433,
Respondent authority in 432.
Yes.
432, 433.
Are you ready in 432?
No, I have not got the instruction.
My lord, everything is
Please come back on 7th December. Because there is already an instruction of the authority. Nothing much needs to be done. Only a direction has to be given for taking necessary steps.
Instead of 7th, any other.
কনসিডার চাচ্ছে না ও ডিরেক্ট অর্ডার চাচ্ছে
ডিরেক্ট অর্ডার রিপারচেজ অর্ডার সিমিলার অর্ডার তো পাস হয়েছে এবং স্পেশাল তো অলরেডি পাস।
আমিও ছিলাম
আরে আপনি
উইদাউট টেকিং ইনস্ট্রাকশন এই অর্ডার পাস করা
নো স্পেশাল তো অলরেডি অর্ডার পাস করেছে আপনার কপি দিলাম।
স্পেশালকে সেটা জেনে নেবো তো যে তুমি এটা কি হবে না
আপনাকে কপি দিলাম, চিঠি দিলাম, তারপরে জানবেন বলে মামলা হ্যাঙ্গিং হচ্ছে আর কি। দিস ইজ রেটিং দ্য পেমেন্ট অনলি।
Yes, Mr. Dev was appearing in the coordinate bench or before the coordinate bench also.
Yes, my lord, only
Yes.
that is the nice.
Learned friend also knows very well.
My lord, otherwise specifically,
Seven
that
is
is
the
the.
difficulty. Come back on 8.
I am appearing 435, my lord.
Because these matters can be disposed of. 8 December.
My lord, the up to 443, the same. Well, only 44, 44 and 45 and 46. This is only, my lord, I prayed for direction be given pursuant lordship's direction. This is
In all these matters.
no, this is two matters, my lord. Physical verification has not yet been done. That I prayed for the lordship pass an order.
So till 444, the same order will be
What-
passed? 444 is a minor matter, it is a different matter.
This is the 444 is the same note. 445 and 446. 445, 46. Your lordship passed an order earlier.
43, the same order will be
Same order.
passed.
Up to 43.
Yes, remaining matters tomorrow.
Well, 45 and 46. Your lordship passed an order. I annexed the document.
Have a diction bench at 2 PM, come back on the next.
No, my lord, this is my lord, the
My lord, your lordship pass every week. My lord, you must take the instruction, otherwise, my lord, up to 46, my lord, up to 46.
no, 40,
My lord, up to
43,
You must take instruction.
8th December,
up to 43.
Learned Counsel for the state respondents seeks to take instructions in this matter. Paragraph, let the matter appear under the same heading on 8th December 2023.
And my lord, so for the
431,
431 to 445.
43. No.
443.
Yes, 443.
Malay
Same order.
Same. And my lord, the 45.
Please give the names, individual names.
My lord, the 45 and 46.
46 next day. 443.
My lord, your lordship, same day, my lord, we must take the instruction. And because, my lord, your lord, he said
This
that he is.
It is the prayer for only for physical verification. Physical verification. Lordship passed an order.
Come, please come. 43 পর্যন্ত হলো same order. 8
Instruction.